One Chairman, since 2014, government has been taking time for taking instruction for disposal of one Bebonos case filed in 2014. खाली it will be disposed.
Specific agent matter, I filed an IA for bail matter. Specific agent is 3 February 2020. After notice admission, after notice admission.
Hello, President Appellants and parent status till 21 2021. But in the meantime, the interveners have filed an IA for the intervention. So intervention, so
It's a repetition.
double.
You will do it.
Another one is a failed admission.
Supplemental list, item number 1.
One, the case for argument that one is time for and substitute.
One is time.
Time for the substitute. Petition number 2 in meantime died.
You are for the
Petition.
petition.
And for the OP file, last occasion also taken time to substitute.
You have not yet filed the petition.
Notice then.
Just to file and
Copy of the
petition,
permission also.
petition for substitution. So how much time you require, madam?
7 days.
7 days. What is your good name?
It's Sahoo.
Yes,
Sahoo Hon'Ble.
S.K.Sahoo. Land counsel appearing for the petitioner. 6-1 in time. Further time for filing petition for substitution as petitioner number 2, Narayan Sahu has died. Put up this matter in the commencing notice of Chhad 11. Copy of the interim application we saw on the land council for the state as well as अपन कहाँ पे हैं
OP file में it's it.
OP Jagannath Temple
Yes.
Mansion as well as the land council hearing for opposite party number 5.
So you have appeared before issue of notice. Is it such a difficult question? Have you received notice in the writ application?
Yes.
You have appeared so much.
Yes, after the notification issued, I have applied.
Notice can be issued. In
इसी को भी सोम तो ये procedure.
हाँ किसी मना नहीं जाने
Available with you.
Please accept that I've already sought instruction with regards to the same from the local council. As
No,
of yet,
you made a submission. It's not that you made a submission and accordingly the it is the reflected in the order
yes, madam.
that London Council petitioner emphatically submitted that the petitioners have constructed the house after obtaining permission from Puri Konark Development Authority, but such permission is not available with him. That is how the direction was given that you are to produce that permission.
Yes, madam. Even I have taken the specific averment in the writ petition that permission I have asked the local council to produce it to me.
No, how much time you it is? 5 years have already passed.
I humbly apologize, my lord. Even They also
We'll
have,
dismiss this writ petition. Next time when the IA will be filed, we'll dismiss on this ground. Okay,
and in the only one peremptory chance may be provided to me if
we are putting this matter, let me place this matter on 17th of so and so. It appears from the order dated 17/2/2020 that to a query made by this court whether permission has been obtained by the petitioners from Puri Konark Development Authority for construction of the house in question. The answer was in affirmative, and accordingly this court asked the Ladin Council for the petitioner to produce the copy of the permission. Stop. Today, when we asked the Ladin Council for the petitioner, Mr. Bhuya, as to whether he is having the permission with him, he submitted that he has to obtain instruction from the Ladin Council for the local council. Almost 5 years is going to be passed. If the Ladin Council fails to produce the permission on the next date, appropriate order will be passed. All right, get it on 24th of February 2025.
Item 2.
You're saying some connected matters are there? How are they connected?
Writ petition 388/2021.
In list you can ask for the prayer.
Next date I'll do.
Item 2.
If my lord, my kindly speak for a moment, next to 72, heat appeal. Page 95. Heat appeal is there, my lord. My lord, see page 95 for a moment. Starts from 93 and it's a 7. The 13 part, my lord, page 95.
No, writ appeal has been disposed of.
Heat appeal has been disposed
So
of.
what review want?
And only for the purpose of 95, the para 5 on the honorable single of the while disposing of writ petition, my lord.
Yes.
Page 95, my lord.
Hmm.
Para 5, my lord. Our joint counsel for petitioner at length taking into account the submission made that petitioner after passing the interim has moved authority seeking framing the necessary rules for grant of free scale of pay. The petitioner is at liberty to make an appropriate application with that to the claim made before the government of P1 regarding framing of rules for grant of free scale of pay in full. According to the petition dispute. But I only grant, my lord, I pray, my lord, that it will given to honorable signature that is given us some liberty that opposite party to move before OP1. Since petitioner made a submission that I have already moved against the impugner before OP1. But since petitioner was filed challenging that impugner after 6 years, his application was dismissed, which was subsequently confirmed by the honorable division bench.
So what review want?
Well, only this quarter is I will give me liberty to move OP1 with the grievance because same person have got the very similar person got the benefits.
No, where is the order in the writ appeal?
My that is in page annex 1, page 23, my lord. 23 in the writ appeal. Sorry, in review.
No, writ appeal order
Review page 23.
No, the order is with us. That is dated 9/7/2024.
Since Madam President will dismiss on the ground that honorable signature dispose of the dismiss of petition since I approached the honorable court after 6 years of rejection. But honorable signature observed that since I have already moved the P1 with regard to the alleging that so petitioner may have liberty to move the P1. pilot permit.
What permit? So that has not been set aside.
It has not-
Order of the single judge has been confirmed.
Dismiss ହେଇଯାଇଛି interpret ଟା।
Because you wanted further direction. କଣ ହେଲା?
Dismissal ସେ କରିବେନି।
ନହେଲେ କରିଦେଇଥାନ୍ତେ ଆଉ।
No,
ମାନେ we have to say that you allow the.
That liberty only.
no question. That is already there. What?
Already there. With that we have not interfered. We have just confirmed.
That part is-
I said that. that.
Some clarification.
that part only has dismiss ହେଇକି ଅଛି।
Let's see. The review petition doesn't. What else? This review petition has been filed for review of the order dated 9/7/2024, passed by this court in writ appeal number 1748 of 2023. It appears that the petitioner Ravindra Mishra filed WPC number 8341 of 2022. Inter alia with a prayer was the order dated order number 7233 dated 22/6/2016, passed by the district education officer. And for the direction to the opposite party to release grant allow trained graduate scale of pay with effect from 9/3/1983 in favor of the petitioner, that is the date on which the petitioner acquired his B.Ed qualification, and extend all such service benefits as is due and admissible to such post within a reasonable time. This writ petition was disposed of as per the, what is the order when it was disposed of?
Appeal June 2020.
What is that order? Writ petition order,
Appeal 95 वाला।
95.
Please appeal that.
Okay. This writ petition was disposed of by learned single judge of this court on 36/2023. And it is observed as follows. Paragraph number 5 of 6 court procedure. Paragraph 5, 6, 7 court procedure. Stop. When this order dated 36/2023 was challenged in the writ appeal, the same was disposed of by order dated 9/7/2024. Wherein it is held as follows, quote from paragraph number 5, 6, and 7. So, the learned counsel for the petitioner submitted that there was a specific direction in the order dated 36/2023, passed by the learned single judge, that the petitioner is at liberty to make an appropriate application with before the authority seeking framing of necessary rules for grant of PG scale of pay. With regard to the claim before the opposite party number 1. And since the writ appeal has been dismissed, in case the petitioner moves the opposite party number 1 in that regard, he may not get any relief. We are not inclined to accept such submission in as much as in the writ appeal no adverse, no contrary order. No contrary order has been passed to the observation which has been made by the learned single judge in paragraph number 5 of the order dated 36/20/23. Accordingly, the review petition is disposed of.
Para 7, para what is the appeal order? Very high. Para 7, CORAM.
আরে dismissed on merit যে যে অর্ডারটা আছে সেটা কেন আমি ইয়ে করলো সেটা সাইড করলো
Next.
Item 3.
ক্লিয়ার হয়ে গেল
Principle of the scope of review. For 47 of the scope of the finding out, they are not inclined to sponsor. Scope of review is on the current period.
Item 3.
Opposite party.
Where is Mr. Guru? Counter? You want time to file counter
My
affidavit?
lord, I have received the counter, but it has not been properly notarized. So I need some time.
So how much time you require?
Only 2 days.
2 days.
Yes. But day after tomorrow, they are going to.
All right. The Learned Council appearing for the Union of India, Mr. Deputy Solicitor General, Mr. Pahi, along with Mr. Bushai, appears for Union of India and submits that the counter affidavit is almost ready and it would be filed within this week. Let a copy of the counter affidavit be served on the Land Council for the petitioner of this matter. Let it come be commencing from 17th February 2025.
One thing I want to add, man.
Yeah.
My lord, the petitioner has challenged notice under section 3 that. But in the meanwhile, on 20, section 6 has been notice under section 6 has been served to him.
Section 6.
Notice under section 6 has been served and he has not challenged the same. So it is not maintainable on that ground.
Just you
I'll
file
file the
counter affidavit file. Yeah. Yes.
Item 4.
IN number 1902 of 2025. There is an application for amendment filed by the petitioner. Copy of the application has been served on the Land Council for the state. After going through the same, submits that he has no objection to the proposed amendment. After going through the amendments taken in the interim application and hearing the Land Council for the respective parties, the prayer made in this interim application is allowed. The proposed amendment and received a proposed amendment now shall form the part of the writ petition. The land counsel for the petitioner shall file the consolidated writ petition within a week, giving copy to the land counsel for the state, right? Yes. Matter will be listed in the week commencing from 17 to 2025. IA is disposed of, your amendment are disposed of. कौन है ना? It is there. The connected रे मध्य गोटे IA ଅଛି amendment पे. That is 1903 of 2025. Same thing, same. अच्छा out गोटे अछि. Out connected अछि 1901 of 25. So all these three IA are disposed of.
Item 5.
तीनटा करे amended writ petition filed. Yes, item number 5. Come to the order number 2, dated 8/1/25. Basic kind बच्ची सरी. Please read out that order. Order dated 8/1/25. Please read.
So hybrid arrangements, video conferencing are physical mode. This writ petition has been filed by the petitioners challenging the order dated hybrid 24 passed by the opposite party number 3, the land acquisition officer Jasper, wherein direction has been issued to the accountant to make payment of the amount in the joint account of Bhagavan Jana, Ananta Kishore Jana and Abhay Jana. Lord and for the petitioner submitted that the mother of the petitioners, namely Annapurna Dhar, filed a civil suit before the Civil Judge Senior Division Judge by CS number 642 of 2022 for partition, and the said suit was dismissed on 24/6/2024 for default and to set aside the dismissal order dated 24/6/2024. The legal heirs of the aforesaid Annapurna Dhar, who died during pendency of CS number 642 of 2022 filed CMA number 79 of 2024 for restoration of the suit and 25/9/2024 passed in the CMA indicates that it was placed for office note on 25/10/2024 when we made a query to the London Council for the petitioners regarding the status of CMA number 79 of 2024. She submitted that there is no such progress in the CMA and she will produce the entire order sheet on the next date. This matter in the week commencing from 27/1/2020. That I will.
Out है सब ने. अच्छा. Next order to place.
This matter is taken up from hybrid.
Charge on the operating part. In pursuance.
Let a copy of
No, in pursuance of the order dated 27/2025 order. Second, third paragraph. Sub paragraph.
In pursuance of the order dated 8/1/25, London Council for the petitioners has published the order sheets of the London Civil Judge Senior Division Dashboard in CMA number 79 of October. That is the partition suit, which is taken on record. It appears that the mother of the petitioners earlier approached this court in WPC number 1401/189 of 2023, which was disposed of on 11/5/2023, wherein directions was given to the land acquisition officer civil Jashpur to refer the LA case number 4 of 2022 to the competent civil court under section 3H4 of National Highways Act 1956 to resolve the dispute regarding apportionment of the compensation amount. London Council for the petitioners of that in pursuance of the order of this court, the matter was referred to by the land acquisition officer to the principal civil court of original jurisdiction, that is District Judge Jashpur in accordingly. CMA number 3 of 2023 was registered and the mother of the petitioners, namely Annapurna Dhar, was the opposite party number 1 in the said CMA. She further submitted that the mother of the petitioners has already expired. When we put a pertinent question to the Law and Council for the petitioner as to whether any steps have been taken for substitution of the deceased mother of the petitioners in the aforesaid CMA number 3 of 23. Law and Council for the petitioner seeks time to obtain instruction in the matter. Matter in the week commencing from 3rd February 2025. Later copy.
So what happened? Have you taken step?
My lord,
This is 3/2023.
my lord. So 21/10/2021. My lord, third page.
On the strength of advancement, record is put up today so in favor of them. File a petition under section so being supported by this to include them as parties on the grounds copies of. So any order has been passed. 21/10/2024 order ta thila 21/11/2024.
ତାପରେ ସେଟା ପଢୁଛି
ହଁ.
ତାପରେ ଉପରେ state of
So now you see in that particular CMA ଯୋଉଟାରେ apportionment ପାଇଁ ରହିଛି ସେଠି obviously ଆପଣଙ୍କର एक issue ଟା ମଧ୍ୟ decide ହେଇଯିବ ଯେ କାର କେତେ ଭାଗ ତ once that is decided ଏଇ ଯୋଉ partition suit ର ଆଉ କିଛି ମୂଲ୍ୟ ରହିବ ଆପଣ partition suit ଟା file କରିଛନ୍ତି ଏଇ purpose ପାଇଁ ଯେ ଆପଣ ଆସିଲେ share ପାଇବା ପାଇଁ ସେ share ସେ issue ଟା district judge is competent as the original ତେଣୁ ଆପଣ ତ allow ହେଇଗଲାଣି ଆଉ what further relief you want?
This is annexure 1 to set aside the order of annexure 1.
What annexure 1?
My lord, that is the land acquisition officer order to disburse the amount in favor of 3 of the post.
No, now so it would be the result of that CMA number 3 of 2020. Yes.
This regarded pertinent was already held by the our Supreme Court. That once the 3H4 application has been filed, the only duty is the principal civil court to decide.
Right, that is pending and number 1 died and now steps for substitution has been taken.
So no other court has any power to decide.
प्रश्न उठुनी आउ परियो
So a judgment that already fully taken care of.
को paragraph
Para 28 to 30.
So obviously the disbursement of the compensation amount would be in accordance with what decision has been taken by the district judge. So that is the thing why.
Any order set aside by the master.
Let us say it
My lord, only
we say that even though such an order has been passed, now since the matter is before the competent court and he has to decide the matter how the apportionment is to be made. So obviously in terms of that order, the disbursement of compensation will be made. Who paragraph ta?
This my lord 3348 33 million. 33 34. Paragraph page 3348.
3348.
33 paragraph. Operating part only.
3348 so who paragraph ta?
33.
33.
कैसे टाकबो?
যেটা কোন তা পূর্বରୁ ওটা 38 প্যারাগ্রাফ রইছে
Paragraph to
এটা ভুল হই যেটা 39 তা মানে আচ্ছা ওলা কোন
We are of the view that when it comes to resolving the dispute relating to apportionment of the amount returned towards compensation, it is only the principal court
প্রিন্সিপাল সিভিল কোর্ট
of civil court.
obviously it is district judge
Decision. The jurisdiction which can do so. Principal civil court means the court of the district.
right
Our higher conclusion is that under if any dispute arises as to the apportionment of the amount or any part thereof of any person to whom the same or any part thereof is payable, then the competent authority shall refer the dispute to the decision of the
it has already been done in this
We
case
have done that. Also to direction of this one. That is their matter that he has that decision is final binding on the part.
right so ଆପଣ କଣ ଭୟ କଣ ପାଇଁ ରହୁଛି
land acquisition officer order ପରେ ସେଇ ଯୋଉ order ଟାକୁ ସେଟା ସେଟ୍ କରିବା ଲାଗି ମୁଁ ଆଉ କିଛି ପାଇଁ ଆସିନି ମୁଁ କହୁଛି ସେ CMA ତ ଚାଲିଛି ତା ଦେହରେ land acquisition officerଙ୍କର କିଛି ସେଠି ରୋଲ ହିଁ ନାହିଁ
Application has been filed. PH4 ଆଉ ବି order କଥା ନାହିଁ କିନ୍ତୁ order ମୁଁ ଦେଖୁଥିଲି the order is considering other parties who have persuaded him to pass such order. If you see the annexure 1.
just to make it clear that now the disbursement of the compensation amount will be on the basis of the order passed by the London civil London districts. This writ petition has been filed by the petitioners for setting aside the order dated 5/8/2024 passed by the Land Acquisition Officer Jajpur, wherein the accountant was directed to make payment of the above amount মানে কোন amount দিতে পারে দেখাইছি
See, do the clearing.
are you amount acha, as mentioned in the said order in the joint account of Bhagavan Jena, Ananta Kishore Jena and Abhay Jena. Stop. It appears that the mother of the petitioners, Annapurna Dhar, filed a civil suit before the London Civil Judge Senior Division Jajpur by CS number 642 of 2022 for partition, and the said suit was dismissed on 24/6/2024 for default. To aside the dismissal order dated 24/6/2024, the petitioners, who are the legal heirs of the aforesaid Annapurna Dhar, who died during the pendency of CS number 642 of 2022, filed CMA number 79 of 2024 for restoration of the suit. And the London Council for the petitioner has produced the order sheet of the CMA number 79 of 2024 before us on 27/1/2025, which has been taken on record. Stop. It appears that earlier the petitioner approached this court in WPC number 14189 of 2023, which was disposed of on 11/5/2023, and direction was issued to the Land Acquisition Officer, Civil Jajpur, to refer the LA case number 4 of 2022 to the competent civil court under Section 3H4 of the National Highways Act 1956 to resolve the dispute regarding apportionment of the compensation amount. And accordingly, the matter was referred to by the Land Acquisition Officer to the principal civil court of the original jurisdiction, that is District Judge Jajpur, and accordingly CMA number 3 of 2023 was registered, wherein the mother petitioners Annapurna Dhar was the opposite party number 1. We asked the learned counsel for the petitioner whether any steps have been taken for substitution of the deceased mother of the petitioners in the aforesaid CMA number 3 of 2023. The learned counsel for the petitioner took time to produce the order sheet, and accordingly today she has produced the order sheet of CMA number 3 of 2023, which reveals that steps for substitution has already been taken. The order sheet, certified copy of the order sheet is taken on record. There is no dispute that the learned District Judge Jashpur in CMA number 3 of 2023 is competent to adjudicate the apportionment of the compensation amount. The learned counsel for the National Highway Authority of India, NHAI, placed reliance on the decision of the Honorable Apex Court, Supreme Court, in the case of Vinod Kumar versus District Magistrate Mau and others, reported in AR 23, Supreme Court 3337, wherein it has been held as follows. Quote from it would be paragraph number 38, not 33. Eta ame ye kor douchu. Setu apana nei jibe sei paragraph number n porjanto. In view of the principle laid down by the Honorable Supreme Court, and since the learned Judge Jashpur in CMA number 3 of 2023 is in session over the matter to adjudicate the apportionment of the compensation amount. We are of the view that the amount is to be finally disbursed in terms of the order to be passed by the learned District Judge Jashpur in the CMA number 3 of 2023, and not in accordance with the order passed by the land acquisition officer in what is that by the order dated 5/8/2024 under annexure 1. तार किछि नंबर अछि annexure 1 टा को proceeding LA case number होछि C/13 of 2022 ठीक नंबर तो
C/4 by
13 all right. With the aforesaid observation, the writ petition is disposed of. Yes.
Item 6.
On implementation, the order dated 27 to 24 in WPC number 37723
On order pass itla.
Order
Come to the operative part of the order. 27 to 2024.
Yes, by non-counsel for the parties, and after going through the papers, this court without expressing any opinion on the date of this issued the petition directing opposite party number 3 to consider the presentation filed by the
Opposite party number 3 की है?
land acquisition officer Mala.
Special land acquisition officer.
Mala.
Yes, कौन वाला पढ़ो तो? to pass appropriate order in accordance with law within a period of 3 months.
madam.
When you produce the date or certified copy of the order,
Yes, madam. I have produced, madam,
Kebe?
postal receipt copy.
କେବେ produce କଲେ?
ମୁଁ କଲି madam ଏଇ 18/3/2024
ଲେଖିଛନ୍ତି?
ମୁଁ ଲେଖିଛି madam. Your lordship may kindly see Annexure 1.
Paragraph 5 ରେ ଲେଖିଛନ୍ତି?
Yes, madam. Yes.
18/3/2024
Madam.
ତାଙ୍କୁ ଦିଆଯାଇଥିଲା 3 ମାସ ସମୟ।
Madam.
କଣ ହେଲା? Instruction you-
The three matters are same. All are
No, we are making it very clear. We will not give you time and dispose of it. It is to be done, you comply the order and communicate the order. So we'll keep, it's not that question of first content, second content. It's not. Select on. The learning counsel for the petitioner placed the order dated 27/2/2024 passed by division bench of this court in WPC number 37723 of 2023, wherein direction was issued to the opposite party number 3, that is Special Land Acquisition Officer, Lawyer Indra Irrigation Project, Khariyar Noapada, to consider the representation filed by the petitioner by the Annexure 3 and to pass appropriate order in accordance with law within a period of 3 months from the date of production of the certified copy of the order. The learned counsel for the petitioner drew the attention of this court to paragraph number 5 of the contempt petition, wherein it is stated that the said order dated 27/2/2024 was sent to the opposite party number 3 by registered post on 18/3/2024. He has annexed the postal receipt. It is the condition of the land counsel for the petitioner that the representation has not yet been disposed of in spite of the aforesaid order dated 27/2/2024. Land counsel for the state seeks some time to obtain the status of the representation filed by the petitioner of this matter, the week commencing from 17 तारीख रखुछु अपन आनिबे similar type of order
Madam.
17/2/2024 ସେଇ type ର order ଦେଖିବେ read petition number with ବଦଳିବ order date yeah.
Item 9.
Non-compliance of the order dated 12/4/2024, madam. Para 5.
Maintain has been complied with order with me.
Complied
I
with.
just my copies my
All right. No, dispose.
5/7/24.
This contempt petition has been filed. Contempt person has been filed for non-compliance of the order dated 12/4/2024 passed by the division bench of this court in WPC number 8670 of 2024. In directing the opposite party number 3 so and so to dispose of the representation filed by the petitioner under Annexure 4 series. The learned counsel for the state has submitted that the order has already been complied with and he has produced the decision taken by the opposite party number 3 on dated 5/7/2024 before us, and a copy of the same has also been handed over.
No, madam, they are not supplied.
That copy.
stop. Let a copy of the order dated decision taken on 5/7/2024 be handed over to the planning council for the petitioner. Stop. In view of the progress made, the contempt petition stands disposed of.
Item 10.
Compliance will be added.
Madam, if I can just get that order as my copies and give it back.
Copy টা দিয়ে দিতে, copy টা sorry. আচ্ছা শোনো, এই ଯୋଉ ଇଏ ଗୁଡାକ ମରା ହେଇଯାଇଛି ନା, ତାପରେ ଗୋଟେ କାଗଜ ପକେଇ ଦିଅନ୍ତୁ ହେଲା।
I'll get it, madam. I'll get it, madam. I'll give it back immediately.
ଆରେ ସିଲ୍ ଟା ମରା ହେଇଗଲାଣି ନା,
ମୁଁ କରିବି।
ହଁ ନେଇଯିବେ ତ?
ଆଜ୍ଞା।
ହଁ ଫାଇଲ୍ କରିବେ ଆଉ
କରିବି।
See that seal portion টা দিন। Yeah.
Item 10.
But has been filed to do the application. Due to error corrected error occurring in the case of the order passed by the honorable
No, read appeal was filed against the single judge order dated 22/10/2023. So that was disposed of, and the division bench was not inclined to interfere with the order passed by the learned single judge. That is the operative part of the order in the writ appeal. Paragraph number 6. So what review want?
But in the paragraph number 6, it is said that the present writ appeal relating to dispute regarding the selection of for appointment in the post of S.K.Sahoo in the year 2006, which post was no more exist. But because actually the post it exists. Only the name the post S.K.Sahoo has been renamed to Junior Teacher Semantic now. And in the different government notification in the review petition, I have attached the annexure 3, that is the copy of the resolution passed by the school and mass education.
Let us come to then the order passed in the writ petition. Let us first come to the writ petition order. Order টা কোথায় annex করছেন আপনারা? Writ appeal annexure 2. Just a minute. 2 order. WPC number 8756 of 2019. It was disposed of on 22/12/2023, right? The border je hot up maro to hundota holo jen so what was your prayer before the learned single judge? Your writ petition?
The prayer was to
you come to the first paragraph of that order passed in the writ petition. That is annexure 2 in the writ appeal. অসুবিধা কোন হচ্ছে আমি বুঝি পারনো প্লেস করুনাহাନ୍ତି
then the annexure 2 that the petitioner to this petition has challenged the order dated 23/2019 passed by the collector and wherein he has rejected the case of the petitioner on the ground that the district selection committee of Noyagarh district in meeting held 13/4/2007 decided that the experience of a ex non-formal instructor of other district will not be taken into account for the purpose of selection, which is in violation of order dated 8/1/2018 passed in WPC number 15386 of 2015.
This is the prayer of the petition to.
Let us come to your prayer portion, the writ petition of prayer. Writ petition. Have you annexed the writ petition?
I have annexed this in the writ appeal. Writ appeal annexed.
Writ appeal, writ petition ta annex korchenti. And in page number 51, the prayer portion is there. Internal page is 16 and running page is 51. So as it appears, you filed the writ petition to quash the order dated 23/2/2019 passed by the collector and district magistrate. Right?
Yes.
So what is that order dated 23/2/2019? In the writ petition that is annexed as annexure 2.
And see the page number 1-3.
23/2/2019 is annexure 8 and it is at page number 64. 64 mane writ petition or 64.
103.
Achha. Okay. 23/2/2019. So if we come to page number, the operative part of that order dated 23/2/2019, we find that in page number, that is the last page, in view of the, please place that, in view of the facts and circumstances narrated above, steady present.
In view of the facts and circumstances narrated above, it is crystal clear that so there is no specific provision in the advertisement to disallow the HNIP of other districts. It is the decision of the district selection committee of Noida district held on 13/4/7 that HNIP of the other district will not be entertained for the time being. Accordingly, the extra mark for the experience should not be added for selection as Simulkonda NRI has been taken certificate of Bhubaneswar in the state. But in the order, it is admitted that she has been given appointment inadvertently without proper scrutiny. When complaint received from different quarters challenging the appointment, it was made and the petitioner found it illegible, hence disengaged. Further, it is pointed out that no opportunity of being had is regarded while disengaging an illegal appointee. Consider the fact discussed about the prayer of the petitioner have no merit, hence rejected.
So, okay. So this is running page kete
105.
105. Okay, just read appeal page number 105. Okay, this order was challenged before the learned single judge, and the learned single judge has come to the operative part of the order. Page number, running page is 32 of that single judge. And I court's reasoning को पढ़े सुन, 31 को पढ़े सुन.
Court reasoning and analysis.
Paragraph 21, সেটা পড়ুন.
Page 49 to mention here that as per resolution dated 31/5/2006 of Government of Orissa in Full and Education Department, the selection of S.K.Sahoo was made taking block as in as the applicant had applied in respect of Gospela block. The petitioner being a resident of the block, she was considered in respect of the Gospela block. After such engagement process was over, complaint from various quarters were received regarding irregularities of the selection process, and considering the above, said complaints of the collector from CO Jilla Parishad Noyagad directed for recasting of the merit list after due scrutiny of all applicants form. On further scrutiny of the application from the petitioner, it was detected that although the petitioner submitted the NAP certificate purportedly issued by the DIFO School Bhubaneswar, which should not have been taken into consideration at time of selection, as it was passed by the proceedings of District Selection Committee Noyagad held on 13/4/2007, that the NF instructor from the other education district could not be entertained for time being, and since he did not work as NF instructor in Noyagad district, but inadvertently he was awarded 20 marks in the previous merit list, which was disclosed after some details reflected in the revised merit list, and accordingly the percentage of mark of the applicant comes to 90.51%.
Yes.
That after recast of the entire merit list, the applicant found placed at serial number 34 under your category, and the last engaged candidate considered the vacancy position under your category was received 94.44 of marks. Percentage of marks. Now there are more number of applicants having more percentage of marks than the petitioner and have not engaged till now due to non-availability of this court, and view of that the did not come with the zone of the consideration.
Okay, so this is the order passed, and that was confirmed by the in the writ appeal. So was the writ appeal order. Yes. Writ appeal order is annexure 1. Come to the operative part.
So there is a ground taken that the court of S.K.Sahoo.
You come to the paragraph number 5. In the 2, 3, 4, there the submission etc. noted down. Now you come to the paragraph number 5.
We are not inclined to interface with the improvement order passed by launch individuals, taking into account the fact that the launch individuals had meticulously dealt with the applicant score and the cut-off score prescribed for your category candidate. But Millard, just I want to
next paragraph.
In the present writ appeal relating to dispute regarding selection for appointment to the post of S.K.Sahoo in the year 2006, which post no more exists.
Yes.
We are not inclined to interpret the order.
Yes, so what is your submission?
The S.K.Sahoo post it exists. Only the name is changed to.
No, that is of the year 2006 now. So whenever it changes, that it was given a different name, that's a different matter. But your case was considered, and why it was you are because you produced that experience certificate of another district was taken into account. So that was the reason why your prayer was rejected when you filed the.
If this argument has been discarded by the Honorable Court in the writ petition 15386 of 2015 order in this Honorable Court. WBC 15386 of 2015 order dated 8/1/2018, and this is in page 1 for page number 141.
What is it?
Please refer to page 141
141.
of the read of it. Read of it.
Yes. Yes.
In the order in the date 8/1/2018,
Hmm.
it is clear that this one last paragraph in that view the matter the improvement order dated 12/10/2006 is what and the opposite party is directed to reconsider the candidate of the petitioner and appoint her as successor as the actress.
No, that is passed in respect of in another case. So how it is relevant?
It is also mentioned that in paragraph 5.
No. This is of the petitioner's case.
No. In this case, if you
Okay.
allow, I just want to read this matter from what is going on from 2007 to till today.
No, this single judge order was in respect of the petitioner. Okay.
Time of advertisement of condition of other educational field or other educational is the main point.
This case, the matter was remanded to that collector for fresh consideration. That is the order. And the collector considered it and passed the order against you, which was challenged before the learned single judge. Right?
But they have in their counter affidavit they have written the same law. There is no extra 8 marks can be added as this is from the other district. But at that categorically honorable has ordered to the district collector to see the resolutions in operation at the time of advertisement in the paragraph 5 last
Paragraph number 5.
5 last line.
Yes, let a fresh order be passed, giving opportunity of hearing to the petitioner within a period of 3 months.
Just before the
5 is place
5.
149.
No, we are having that order.
It appears.
The,
It appears that the matter was taken up by the competent authority.
Hmm.
Pursuant to the aforesaid direction of this court, perusal of the impugned order at Annexure 7, it becomes clear and apparent that the decision involving the issue has been taken following the guidelines circulated on 6/8/2013. Admittedly, has no existence at the time of advertisement. Law is fairly settled. The document not seen the light of the day should not be taken into account. Considering that the advertisement was issued based on a set of circulars, resolutions existed then, but the prospective nature of resolution applied in deciding the case of the petitioner, this court finds. The impugned order and annexure is not sustainable in the eye of law. As a consequence, this court, interfering in the impugned order and annexure 7, sets aside the same and remits the matter back to the competent authority, that is the collector cum chief executive officer, Jilla Parishad, Sarva Sikha Abhijan Noyagarh, opposite part number 3, for giving a fresh look to the grievance of the petitioner and passing appropriate order remaining with the circular and resolutions in operation at the time of advertisement.
okay, this was the specific order. Just a minute. Okay. Do you mean to say that the collector did not take into account this? Let us see. At the time of operation, so let us see that collector's order, which was challenged in the writ petition, of course. Come to the writ petition. Writ appeal se order ta next is. That order is page number last page upon the putile. We have underlined page number 103. Right. That order has been also quoted in page number 104. 104 or last paragraph question. Did you get it? Please place that last paragraph.
Again, being agreed on the order dated 7/8/15 passed by the collector from Chief Executive Officer Jilla Parishad Noyagarh, the petitioner filed WPC number 15386 of 2015 before the Honorable High Court of Orissa, which is also disposed on 8/1/18.
This was the decision Justice Roth disposed of, single bench. Yes, then who set aside?
The order on dated 7/8/15 passed by the collector from Chief Executive Officer Jilla Parishad Noyagarh and remitted the matter back to the competent authority, that is the collector from Chief Executive Officer Jilla Parishad Noyagarh, for giving a fresh look to the grievance of the petitioner, called for passing appropriate order basing on the circular and regulation in operation.
So this is most important. Basing on the circular and resolution in operation at the time of advertisement. Okay. Now what he has done, let us see.
Accordingly, the present miss case is instituted at the time of hearing. The petitioner again reiterated her claim that she has secured highest percentage of marks than the last selected candidate, so she praised the appointment for S.K.Sahoo basing on the conditions laid down in the advertisement. The DPC SSA Noyagarh, present with all documentary evidence, has stated that the petitioner was appointed as S.K.Sahoo in the Daspala block in response to the advertisement of government in the year 2006. After the process of engagement was over, some complaints were received from various quarters regarding illegalities and irregularities committed in the selection process. Collector cum Chief Executive Officer Jilla Parishad Noyagarh directed for a recasting of the merit list after due scrutiny of the application form. It was selected that the petitioner has filed NFI certificate issued by the DIFO School of Bhubaneswar, which not taken into account as per proceedings of a district selection committee, where it has been clearly mentioned that the NFI certificate from other educational districts should not be entertained. For the timing after recast of the merit list, the applicant found place in serial number 34 on the UR category, and the last engaged candidate of a UR category has
secured. So it was when the advertisement was issued, that makes it very clear that NFI certificate, if it is issued by some other district, from some other educational district, that is not to be taken into account. So whatever you produce, that your NFI certificate was issued by DI of Schools Bhubaneswar. So obviously that should not have been taken into account. That was as per the advertisement.
And for the advertisement, there is nothing in the advertisement mentioning that other educational districts should not be considered. Case number in the advertisement is page number 4 of the writ appeal. The original advertisement of the newspaper.
Writ petition টা তো ଅଛି, writ petition advertisement টাকে excerpt କରିଛନ୍ତି.
Annexure 1. 64.
କୋଉଠି ସେ ଲେଖିଛନ୍ତି ସେ ବିଷୟରେ?
ପାରା 8 8 ରାଜ୍ୟର ପ୍ରଚଳିତ ସାର୍ବଜନିକ ପ୍ରାଥମିକ ଶିକ୍ଷା ପାଇଁ ବିଭିନ୍ନ ଯୋଜନାରେ ଡିପିପି ଇଏଫଏ ଏନ୍ଏଫି ସରକାରୀ ସଂସ୍ଥା ଦ୍ୱାରା ନିୟୋଜିତ ହୋଇ କାର୍ଯ୍ୟରତ ଥିବା ଏବଂ ଆବଶ୍ୟକ ଶିକ୍ଷାଗତ ଯୋଗ୍ୟତା ଥିବା ପ୍ରାର୍ଥୀମାନେ ଅଗ୍ରାଧିକାର ଭିତ୍ତିରେ ସେମାନଙ୍କର ଏଜାବତ ଅଭିଜ୍ଞତାରୁ ଶିକ୍ଷା ସହାୟକ ରୂପେ ନିୟୋଜନ କରାଯାଏ। ଡିପିପି କାର୍ଯ୍ୟକ୍ରମରେ ନିରବଚ୍ଛିନ୍ନ ଭାବେ ନିୟୋଜିତ ହୋଇଥିବା ଏବଂ ସିଟିବିଟି ଯୋଗ୍ୟତା ହାସଲ କରିଥିବା ପାରା ଟିଚର ମାନଙ୍କୁ ସେମାନଙ୍କ ଅଭିଜ୍ଞତା ପାଇଁ ବାର୍ଷିକ 5 ମାର୍କ ଲେଖାଏଁ ସର୍ବାଧିକ 3 ବର୍ଷ ପାଇଁ 5 ଗୁଣ 3 15 ମାର୍କ ଦିଆଯିବ। ସେହିପରି ଡିପିପି କାର୍ଯ୍ୟକ୍ରମ ନିରବଚ୍ଛନ୍ନ ଭାବେ ନିୟୋଜିତ ହୋଇଥିବା ଏବଂ ସିଟିବିଟି ଯୋଗ୍ୟତା ହାସଲ କରିଥିବା ପାରା ଟିଚର ମାନଙ୍କୁ ସେମାନଙ୍କ ଅଭିଜ୍ଞତା ପାଇଁ ବାର୍ଷିକ 5 ମାର୍କ ଲେଖାଏଁ ସର୍ବାଧିକ 3 ବର୍ଷ ପାଇଁ 15 ମାର୍କ ଦିଆଯିବ। ଯେଉଁ ଏନ୍ଏଫଏସ୍ ମାନେ ସିଟିବିଟି ଯୋଗ୍ୟତା ହାସଲ କରିଥିବେ ଏବଂ ତା 31/3/2001 ଯାଏଁ କାଟିଲେ ସେମାନଙ୍କ ଅଭିଜ୍ଞତା ପାଇଁ ସେମାନଙ୍କୁ ବାର୍ଷିକ 4 ମାର୍କ ହିସାବରେ ସର୍ବାଧିକ 5 ମାର୍କ 4 ଗୁଣ 5 20 ମାର୍କ ଦିଆଯିବ। ତ ଏଥିରେ ଅନ୍ୟ ଜିଲ୍ଲାର
ଏଇଟା ଆପଣ ଏଇ ଯୋଉ ଗ ଭିତରେ ଆସିବାକୁ କହୁଛନ୍ତି। Your case comes within this ଆଉ ଥରେ ଟିକେ ପଢନ୍ତୁ।
ଯେଉଁ ଏନ୍ଏଫଏସ୍ ମାନେ
what is full form of that?
non-formal instructor, non-formal
अच्छा non-formal एस गुड अच्छी non-formal एस कौन?
I am non-NFI.
You are NFI माने non-formal instructor अच्छा non-formal instructor हाँ माने सिटी बीडी योग्यता हासिल करिथिबे एवं 31/3/2001 तारीख जाए कार्यरत थिबे सेमानंकर अभिज्ञता पई सेमानकु 4 मार्क हिसाब रे सर्वाधिक 5 वर्ष पई दिया जिवो। तो एइटा आपणकर कहउचंती जे सेमिति किछि नथिला जे सेई जो अभिज्ञताटा सेई एजुकेशन डिस्ट्रिक्ट रे हेतिवा दरकार सेमति किछि नाही।
ଯେତେବେଳେ ତାଙ୍କୁ ଡିସେଣ୍ଡେଡ୍ କରାହେଲା ରିପିଟିସନ ପ୍ରଥମେ 2010 ମସିହାରେ ରିପିଟିସନ ଫାଇଲ କଲେ ଏଇ ଲଜିକ୍ ହିଁ ସେ ଦେଇଥିଲେ ଏବଂ ଆଟ୍ ଦାଟ୍ ଟାଇମ୍ ରିପିଟିସନ ନମ୍ବର 2010 150
So एइटा तो मिस्टर नायक
at that time also the honorable
एटा क्रॉक्स भी थ्रू पड़े जाउची एटा वेरी क्रॉक्स ऑफ द मैटर दैट आपणकर जदी अन्य डिस्ट्रिक्ट रो जो एक्सपीरियंस को आपण काउंट करिवे नाही केवल सेई डिस्ट्रिक्ट रो ये काउंट करिवे ए जदी नाही ताले ए तो
नहीं से कौन प्रिंट आउट काढछन जे मतलब के मागिला प्रिंट आउट सर मागिला कौन करछन
व्हाट जजमेंट
सो आपण आनिबे एठु होला वाले काढिबे
this is disturbing the court proceeding. How you are passing the instruction in some other case?
करने so not the way
You are right that ये जो advertisement रे सेमती किछि नाही जे अन्य डिस्ट्रिक्ट रो जदि आपणकर एक्सपीरियंस थिबो सेटा को आपण काउंट करिवे नाही केवल सेई डिस्ट्रिक्ट पई थिले काउंट करिवे एटा नाही
सो सेटा को बेसिस रे करले आपण
ए एडवर्टाइजमेंट पछरे जदि नोटिफिकेशन थिबो
नहीं भीतर की आगुरु सेटा चेक
कलेक्टर सेई जिंसटा को रेफर करिसेंती जे तापरे हम गोटे डिसीजन निया गला जे केवल सेई डिस्ट्रिक्ट रो ये थिले निया जिवो तेनु सेटा तो एडवर्टाइजमेंट रे जेतले नाही ଏଟା କେତେବେଳେ ନେଲେ ଆପଣ ସେ ଡିସିସନ ଟା?
ଆଗରୁ ଯଦି ଥିବ subsequently ହେଲା, it is a different matter.
That is the order of the
And whether it has been done for everybody, ଆଉ ଆଙ୍କୁ ଖାଲି single out କରିକି ଗଲେ ହବ, ସମସ୍ତଙ୍କୁ ଯଦି that procedure has been followed, that again is
It's
different.
not an advertisement. There has to be a notification based on which this advertisement has been published. If it is not, then the notification as an advertisement.
The order of the Justice Vishwanath Roth,
I have seen.
his lordship, he is very clear that
Very-
you are to.
very.
No,
It will take from the interest for the- check କରିକି ଦେଖିବାକୁ ପଡିବ point out.
I want to.
just a minute. This review petition has been filed. A prayer to modify the order dated 29/10/2024 in writ appeal number 1348 of 2024. And also to set aside the order dated 22/12/2023 passed by the line single judge of this court in WPC number 8756 of 2023. Inter alia with a prayer for a direction to the respondent to give reappointment to the petitioner as a regular teacher and to give all subsequent benefits from 2000 to the petitioner from 2017. Which she would have got if she would not have been disengaged illegally. During course of argument, the learned counsel for the petitioner drew the attention of this court to the order in WPC number 15386 of 2015, which was filed by the petitioner, wherein the interim order under Annexure 7 what was the Annexure 7 in that writ petition?
Of the order dated 8/1/2018.
Huh?
Copy of the order dated 8/1/2018.
Define Annexure 7. अच्छी से रिट पिटिशन कॉपी अच्छी अपन पर हाँ देखिए 15386 of 2015 Annexure 7 तक
Annexure 4, my lord, writ appeal Annexure 4, a copy of the writ petition bearing number WPC number 15/2004. Annexure bearing number 11. Writ appeal 1.
ସେଟା Annexure ଗୁଡାକ ଦେଇନାହାନ୍ତି ଆପଣ ଖାଲି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ନେଇଛନ୍ତି है ना କଣ ଲେଖିଲେ that is the rejection order dated 7/8/2015 passed by the collector from CEO Jilla Parishad. Now you come to that page ଯୋଉଠି ମୁଁ ପଢୁଥିଲି ଯୋଉ ଚିହ୍ନ ମରା ହେଇଥିଲା was set aside and the matter was remitted to the competent authority, that is collector chief executive officer Jilla Parishad Sarva Shiksha Abhiyan Nayagarh, opposite party number 3, to give a fresh look to the grievance of the petitioner and pass appropriate order remaining with the circulars and resolution in operation at the time of advertisement only. The learned counsel for the petition place the place the order of the collector, that is at page जोटा impugned ହେଇଥିଲା writ petition ରେ no order collector जोटा consider कले से order टा कहीं order टा pass yes Peter. Contempt and District Magistrate Nayagarh dated 23/2019, which was passed in terms of the order passed by the learned single judge in the aforesaid WPC number 15836 of 2015. And it was observed that the petitioner was appointed as S.K.Sahoo in the Daspala block in the year 2006 in response to the advertisement of the government However, when some complaints were made regarding illegality and irregularity committed by in the selection process, direction was issued by the collector from CEO Jilla Parishad Nayagarh for recasting of merit list after due scrutiny of the application form, and it was detected that the petitioner has filed NFI certificate issued by DI of Schools Bhubaneswar, which should not have been taken into account as per the proceeding of District Selection Committee, wherein it has been clearly mentioned that the NFI certificate from other educational districts should not be entertained for the time being.
Being dated 30/4/2007.
Acha. Such decision the proceeding of the District Selection Committee wherein such a decision was taken is dated 30/4/2007 to 2007. Stop paragraph. It is the contention of the Learned Counsel for the petitioner that when the advertisement was issued in the year 2006, there was no such stipulation that the NFI certificate from other educational district shall not be entertained. Therefore, the subsequent decision which has been taken in the proceedings of District Selection Committee on dated 2007 cannot be a basis to recast the merit list of the petitioner. Stop. The Learned Counsel for the state seeks some time to obtain instruction in the matter. Put up this matter in the week commencing from 24th of February 2025.
Copy of the order may take.
Free copy of the order be handed over to the Learned Counsel for this. You see, गोटे केस आपणकर 2006 मसीहारू 5टा 6टा ये करछन्ती आपणकर प्रिपरेशन आमे जेतिकी एठी स्ट्रेस नै कि ये ऑर्डर एठी जा सेठी जा एगुड़ा आपणको तरफरु हबा कथा गोटे सिस्टमैटिक मैनर रे बट सेटा प्रिपेयर you are filing a review petition and the scope is very limited. Yes. Extra copy of the review petition be served on the land council for the state court.
Then that way, my lord, since the matter now, more or less, the point has been formalized. My lord issues notice. I'll have more than I can call them for a discussion. And seasons of instruction.
Point of the order. It would a valid point as you raised good.
You get instruction thereafter.
You,
Necessary we should
you
not
get
get.
the instruction, thereafter we'll pass it.
Ma'am.
Yes.
Another thing is, if it has been done for others also, then that whole selection process has to be done. If you have done it for everybody,
Advertisement रे सेमती किछि restriction नथिला admittedly देखि चलुने हम आपण गोटे subsequently 2006 रो advertisement सी apply कर देले 2007 रे आपण कहले जे अन्य education district रो हेइथिले सेटा consider करिवन.
that cannot be applied retrospectively to his.
That is exactly the
Yes.
decision of Justice Roth that
I see.
and ଆପଣ ବର୍ତ୍ତମାନ fresh collector ସେଇ basis ରେ ତାरକୁ काटी देले तार ये रिक्वेस्ट कर देले on the basis that the point which she has received for that
Experience. That has been
experience
deducted.
for other district.
for other district that will not be taken into so the ground basis that was
Also, you have to examine whether other parties have to be implemented. The ones who have been selected, that also is another point. In a selection process, the parties who have been, I mean, they are enjoying because the appointment have that also you have to be examined whether they have to be made parties and should notice.
The rate appeal is relegated back. It is restored back to 5.
So you mean to say without much effort, we should do it so that
No,
your work is lessened?
No,
Then-
my only submission was.
No, your submission is to be asked for a counter and then you
The
don't have
counter
to
is not fine. At least
no,
I can.
you get instructions
I'll
and
do.
thereafter we can do the same
I'll
thing.
do.
Because as you know, the scope of
Review is
review,
very limited.
but if there is a point, we can.
Ma'am.
yes next no we have just come within 2 minutes.
Plus this matter from starting from 17.
No,
The common judgment.
we are in item number 11.
17.
17 we have not reached.
I guess.
We have not reached 17.
So, it's 11
We are in item number 11.
ଚାଲିଛି
ଠିକ ଅଛି ରିଚ୍ କଲେ
ଚାଲିଛି ନା ସରିଲା 10ଟା ଆମେ କେବେ ରଖିଲୁ
First instruction period. 17 ne kebe rehta? 24 to 20. Yes. Yes.
Item 11.
Having a piece of land. Out of that land, 14 district land was acquired by the National Highway Authority of India in the year of 2004, my lord.
You approached this court earlier.
Yes, my lord. That is WPC number.
No, where is that order?
My lord, 39.
No, we are asking, have you annexed that order?
I thought annexed.
Annex that order. How many times you have approached this court?
This is the third round review application, second round review application.
File all those orders. Let us see. File policy order. It appears from the first title of the writ petition that the petitioner earlier approached this court in so and so, page number 3 let the learned counsel for the petitioner file the copy of the orders put of this matter in the commencing from 17th. Yes.
May one review application is in the petition report may list along with that is RVWB number 120 of 2022.
It is against which order?
In WPC number.
No, review petition is to be assigned to a particular bench in which one of the judge is a party to the, if suppose let us say it's a division bench order.
Division bench order.
So division bench order, if it is one of the judge is still there, it has to go to that matter. We cannot take up that matter as such in a routine manner. Whether that review petition has been the writ appeal.
Not writ appeal against WPC number 3399 of 2019.
Yeah.
Against division bench order. Honorable Justice S. Muralidhara and Justice part.
So it has to go to. Why we will list it? It has to go to one of the judge. Petition cannot be taken off if Justice B.P. Rao is a party to that. So it has to go.
My Lord and Senior Mr. Mahati appearing on behalf of let me direct to short copy.
Which copy?
Copy of the
You first file the petition, we'll see that.
Oh, right.
Yeah. Next.
Item 12.
Representation is annexure 4. It is pending before whom? That is opposite party number 3. All right. Dispose of it. Next.
Item 13.
Is a developer engaged in the business of real estate housing projects since 2001, and they have business in Gurgaon, Bhubaneswar, and they have successfully developed a lot of residential projects. And then one of the residential projects, which is Vipul Greens in Bhubaneswar, there was a delay in delivery of the flats to the allottees, and 17 cases were filed before the Real Estate Regulatory Authority. Now, the RERA in this case had passed an order of interest which is to be paid by the petitioner to the allottees. And challenging that order, the petitioner had filed an OVAT appeal against those 17 cases. But unfortunately, due to non-deposit of the statutory amount, those appeals got dismissed. But after those appeals were dismissed, there were certain preliminary points of law which the petitioner had raised before the ORIAT, but those were not considered. So now in these cases, execution has been filed, which is now pending before the Additional District Magistrate Bhubaneswar. And the execution cases have reached to a stage where a notice of arrest has been issued against the petitioner.
Yes.
Case here,
What? From 2021. The order which is influenced before us is 26/11/2021, and thereafter you said that execution proceeding instituted, this, that, done. So what we are doing for last 3 years, more than 3 years have passed.
appeal time where my appeal was pending before the ORIAT was from 2020 to 2021. My lordship, this is the period where the COVID-19 pandemic was also coincidentally had stopped during that time. My lord, the amount which has been imposed as interest.
No, on that day, as it appears, the order was passed on that day, and the counsel for the appellant also appeared on that day, and it appears perhaps on before that order was passed. So
It was passed, my lord. It was
So,
passed, my lord.
if it was passed in your presence or in 2021, 26/11/2021, why you have approached this court in 2025? That is our first query.
My reason to approach this court is that the amount which has been imposed as compound interest has been also imposed retrospectively before the RERA Act had come into force in Odisha. Well, this amount has compounded now
It has
into
been held in
multiple.
that is a pre-deposit was mandatory as per 43(5) of the Real Estate Regulation and Development Act 2016 for maintaining the appeal. You did not deposit that amount. That is how your appeal was dismissed for non-deposit of the statutory amount. Order was passed in 2021, and you are coming to this court in 2025. Now you are telling that so many things have been done, and so why you will entertain effort?
One point is, amount has compounded into multi-crores, not even crores. 17 cases. And for me to arrange this amount as a builder, I am supposed to give houses to people. But now, if I'm going to arrange this amount, I'm definitely reach a stage where I have to close my business, my lordship.
No.
My issue was that this interest amount has been.
You are not
imposed-
answering to our point. Why you approach this court at a belated stage? Execution proceeding was instituted, and execution proceeding is almost on the verge of the completion. And you are now coming to set aside an order of 2021.
Related, my lord, because till now I am still trying to arrange this amount. Even before the ADM, while this execution is going on, I had approached the ADM to accept, to engage a local council, to accept a wakalatnama on my behalf to show cause why this should not be, why the execution, to allow me a chance to represent myself. The same has been rejected by the ADM.
Where is that? Where is that?
My lord,
He's not allowing you to be represented by
it is not
council.
allowing me
Let us
to
see.
be represented. My lord, I have taken
Real estate article 2016 Act.
and because he's not allowing me to represent myself, I am also unable to get a certified copy of the order where he's rejecting my representation. But I've taken pleadings in para 8 of my writ petition.
The order, the provision is very clear. 43.5, any person aggrieved by an action or decision or order made by the authority or by an adjudicating officer under this act may prefer an appeal before the appellate tribunal having jurisdiction over the matter, provided that where a promoter files an appeal, you are the promoter, with the appellate tribunal, it shall not be entertained without the promoter first having deposited with the appellate tribunal at least 35% of the penalty or such higher percentage as may be by the appellate tribunal, or the total amount to be paid to the allottee, including interest and compensation imposed on him, if any, or with both as the case may be, before the said appeal is heard. So you did not deposit that. Opportunity has also been given, and that was the reason why the order dated 26/11/2021 was passed in QRAT Appeal number 50 of 2020.
The amount, definitely it is going to take me time to arrange this huge amount which is now in force. But at least before the AGM, as per section 8 of the OPDR Act, my lordship, I am allowed to represent myself. But that has also been denied. When I'm appearing, and they have sent me multiple notices, I'm appearing each time, but each time they're denying my.
Now, what about section 58? Section 58 of the Real Estate Regulation and Development Act 2016.
Appeal to High Court.
Yeah.
But my appeal before the ORIAT has not yet been, but it has been discussed, my lord.
What has been done? Your appeal has been allowed.
It has been.
Are you not aggrieved by an order passed by the appellate tribunal? And it says that any person aggrieved by any order of the appellate tribunal has to prefer an appeal to the High Court, and that too within a period of 60 days. So if you are aggrieved by the order of the appellate tribunal, you are to file the appeal, and that too within 60 days. And there is a provision also that provided that High Court may entertain the appeal after the expiry of 60 days if it is satisfied that you are to file the application for condonation that under the Limitation Act or under this provision. So that you have not done. You are filing when the alternative remedy is available by way of an appeal. Why will entertain this writ petition?
My appeal before the ORIAT was entertained. It was because of the statutory deposit. So basically, it was not even an appeal which was decided on merits or an order was passed. My lord.
Disposing of it.
Conciliation order है ये. Appellate tribunal order का क्या? Page? Page?
That is the page annexure 1 series which is challenging.
Page 50 is the operation, page 80.
Why you saying it has not been entertained? There is one order.
Appeal is dismissed.
It was dismissed for non-deposit of.
So whatever it may be,
That is an order.
this writ application has been filed challenging the with a prayer for restoration of the appeal filed by the petitioner and to decide the amount of statutory deposit to be paid by the petitioner and for the further direction to the additional district magistrate opposite party number 3 to provide an opportunity of hearing to the petitioner through the legal heirs. It appears that the petitioner the promoter filed variety appeal number 50 bracket T of 2020. Under section 50, 43 bracket 5 of Real Estate bracket Regulation and Development Act 2016. Which was dismissed for non-deposit of the statutory amount. Section 43(5) of 2016 Act, here after 2016 Act, is quoted here in below. Top. Section 58 of 2016 Act states about the appeal to the High Court, and which deals appeal to the High Court states that any person aggrieved by any decision or the order of the appellate tribunal may file an appeal to the High Court within a period of 60 days from the date of commencement, communication of the decision or order of the appellate tribunal to him, or on any one or more of the grounds specified in section 100 of the CPC. It has been further provided that the High Court may entertain the appeal after expiry of the period of 60 days if it is satisfied that the appellant was prevented by sufficient force from preferring the appeal in time. Since against the order dated 26/11/2011 passed in Variety Appeal number 50 bracket T of 2020, and appeal provision is there, we are not inclined to entertain this writ petition, which is accordingly disposed of.
Permitted to file an appeal, ma'am.
Permission is not necessary. You have a right, statutory right.
APM, my lord, at least I should be given a right to represent.
Issue 1C.
Meaning of this is that you can file appeal.
And you have to file separate appeals also. Not this one writ petition, this separate appeal again, because the appeal numbers are different, and the order which has been passed, that is also different. Hala, sab guda kar rakhiye. There Gutti order, I mean, instead of Gudai order, appeal order, annex question, the annex 1C.
Appeal number
Number ka mention. Date of deposit is also different. Yes, next.
Election represented before the ADM, my lord, they are not accepted.
Sorry, your writ petition is not maintainable. Yes, next.
Item 14.
Paying for that of compensation on under resettlement and rehabilitation policy of government of Odisha on account of loss of our house structure and due to land acquisition. As by the
You approved this quote earlier.
my lord, approach this court, my lord.
In last time when you approved this quote?
My lord, that is annexure
7.
7, my lord.
What
You
order
have
was
the,
passed?
Honorable Court has been to direct the collector to consider the requirement. For the collector passed the order under Annexure 8, that he has no jurisdiction. The Honorable Claim Commission has the jurisdiction. For now, the office of the Honorable Claim Commission is not functioning. Therefore, file this case once again.
Who is opposite party number 3?
My lord.
In the writ petition which you have filed, opposite party number 3, the collector.
My lord, collector.
Acha. So now since there is no extension given to the claim commission, so the collector is to adjudicate the matter. Annexure 7 was passed at that point of time. He was right that now since whether the collector is the competent authority to decide this matter. Yes.
My lord, now collector is the officer. This is the new code of the Claim Commission is not now.
Claim commission ro claim commission just BN Mahapatra
Oh, sorry,
the 4 तारीख के जजमेंट हला जनवरी एक्सटेंशन जोटा कॉलेनी जो जस्टिस बेला द्विवेदी और जजमेंट सेटा 4th January you have got that order with you.
What is the citation? Is it reported?
Yes, no report nahi.
By INC.
I also posted in reference to
Yeah, my lord. Para, co-para?
para 15 minutes.
सेटा बेला
हाँ,
मान देखो लास्ट टू क्वेश्चन
देखिए
8 January में सिटी पहले extension पे ଗୋଟେ paragraph ରହିଥିଲା in our opinion the covenant extension ଟା କୋଉଠି ଇଏ କଲା
ଆଉ ଗୋଟେ judgment ହେଇଛି।
24 ଲେଖା ହେଇଛି।
ହଁ
ହଁ, ଏଇଟା ଗୋଟେ
para 24
24 on 20. In view of the above, it is directed that High Court shall decide the writ petition being sworn so as to remove also the MCL shall make payment and the comment is it is clarified that we have not expressed any discouragement so and so. It is extension would have monaco in the aforesaid premises, no further order for extension of the term of commission is passed. So that is the order.
କେତେଟା judgment ସରିଲାଣି
Hmm? connected you would have. ପ୍ରାୟ ଅଗଷ୍ଟ ମାସରୁ କି ଜୁଲାଇ ମାସରୁ ବୋଧେ କମ୍ ହେଇଯାଇଥିଲା ଅର୍ଡରଟା ରିଜର୍ଭ ଥିଲା ତାପରେ ଫାଇନାଲି ଏକ୍ଜିକ୍ୟୁଟ କରି ଏକ୍ସଟେଣ୍ଡ ଦେଲେନି। So, Mr. Nair, in this case, this order which was passed earlier, now in terms of that, the collector who's again decide the matter, that means he should go. This order has to go. This 17/11/2023 order has to go, and he has to adjudicate it afresh in terms of the order passed by the single judge in division bench in 25/8/2023 in WPC numbers also. 25/8/2023 order को पढ़े आसंतु page number 54 रे, right? So it was directed that the representation is to be disposed of within 3 months. This writ petition has been filed by the petitioner Mahima Naik. With following prayers for the, it appears that earlier the petitioner approached this court for self-same relief in WPC number 26918 of 2023, which was disposed of on 25/8/2023, and without expressing any opinion on this of the case, this court directed opposite party number 3, collector from district magistrate Sundargarh, to consider the representation filed by the petitioner and to pass appropriate order in accordance with law. However, it appears from Annexure 8, which is the final order passed by the opposite party number 3 on dated 17/11/2023, that since the Honorable Supreme Court filed orders in SLP C 6933 of 2007 has constituted Claims Commission to decide upon the land and structure compensation and approved genealogy of the land hostage families of 12 villages, including the village of the petitioner, Jupurunga. It was held that he lacks jurisdiction to decide the matter, and the petitioner was asked to approach the appropriate forum to pursue for remedy. The Land and Council for the petitioner submitted that in view of the order passed by the Honorable Supreme Court on 3rd January 2025, in the case of Mahanadi Coalfields Limited and another versus Matthias CORAM and others, in miscellaneous application number so and so number ta diya hai and in SLP number so and so, the term of the commission has not been extended. Claim commission has not been extended, and therefore the opposite party number 3 has to comply the order passed by this court on 25/8/2023 in the aforesaid WPC number 26918 of 2023. Within a specified time limit. The Learning Council for the state has no objection to the prayer made in the writ petition regarding the fresh adjudication to be made by the opposite party number 3 on the representation filed by him. In view of the submission made by the Land Council for the respective parties, and after going through the averments taken in the writ petition, the order dated 17/11/2023 passed by the opposite party number 3 under Annexure 8 is hereby set aside, and the matter is remitted back to the opposite party number 3, who shall comply the order passed by the division bench of this court on dated 25/8/2023 in WPC number 26918 of 2023 and consider the representation filed by the petitioner in accordance with law. Within a period of 3 months term within a period of 6 months from the date of production of the certified copy of this order. Accordingly, the writ petition is disposed of. The 8 are Lekki, the 2025 INST 2023.
Item 15.
May I please, my lord?
Yeah.
Madam, the only grievance is, despite an objection raised for the Land Acquisition Authority to the effect that certain persons to whom they intend to disburse the compensation are not entitled to the compensation, a reference in terms of Section 64 of the Act 2013 is not being made. And initially, the property in question was recorded in the name of the mother of the petitioners, that is the first wife of one Kasim Khan. Now, my lord, your lordship, that was under Annexure 1 series. Subsequently, after her death,
just a minute. LA case number 20 of 2020.
my
Where it is pending before the opposite party number 3.
My lord, he has to make a reference once an objection is raised. In terms of 64, he has to make a reference.
No,
what is
the stage now?
My lord, he has disbursed the amount. But that will be adjudicated because he has made a reference. Once he makes a reference to the competent authority, my lord, then the adjudication will be made. That he is not doing. That is my limited grievance.
No. You said that that has already been disposed of and compensation has been disbursed.
Compensation he has disbursed, but he has to make a reference. He could have very well made a reference without disbursing. But in the meanwhile, he has disbursed. That is the final instruction I have received.
Orders have been passed in that LA case number 20 of 2020. What is the order sheet?
That order sheet, my lord, he has only Annexure 6 page 30, your lordship will see.
No, that is a copy of the letter. You produce the order sheet of that LM case number.
My.
In this writ petition, prayer has been made for a direction to the opposite party number 2. Zone officer cum land acquisition officer, Subarnarekha irrigation project, Bahalda zone, Bahalda, in the district of Mayurbhanj, to refer LA case number 20 of 2020 to the competent authority, opposite party number 3, since the LA case is of the year 2020, let the land council for the petitioner produce the order sheet of the said case on the next date, which is fixed to 17th of February 2025, are Mr. Mishra and senior advocate for the petitioner. Yes.
Madam.
Item 16.
I have my annex 2 is pending for office back number 3.
Or I dispose of his. These are all the matters which has come after the order was passed by the Honorable Supreme Court. Narottam Rath. And these are all the connected matters. What was the order passed by the Honorable Supreme Court in that?
That is flag 10 matters.
Flag
10, flag number 10 of the Lordship 3.
Flag number 10.
Madam.
Achha.
Lordship front, the order begins from page 6.
Cost
title is for 5 pages.
Please place that order. Mr. Mishra, if you work from group, please come now. Then it's all.
Speak on roll. Having heard the running counsel for the parties, we are of the considered view. The judgment needs to be quashed and set aside for the simple reason that instead of deciding each case individually on its given fact, the High Court proceeded to club and decide all the matters that presuming the facts to be common/identical and framing a common question of law. As such, on this short ground alone, the judgment requires interference. We are of the considered view that each case had to be considered on its own merits. Whether the power exercised by the ASO under the provisions of Section 12 of the Orissa Survey and Settlement Act 1958 were exercised prior to the finalization of the record of rights or at a subsequent stage was not considered by the High Court. Also, as to whether the aggrieved parties had exhausted the remedies as provided under Section 12A or Section 15B of the said Act was also not considered by the High Court. The High Court proceeded on the assumption that all the petitioners before the court had leases in their favor, in relation to which no record of right was required to be prepared in terms of Section 12 of the said Act. As such, on these grounds alone, without commenting on the merits of the
Resettlement Act.
and the contentions raised before us, we remand the matter to the High Court for consideration of that. We hope and expect that each case will be considered and decided separately and though expeditiously. All rights and contentions inter parties are left open.
So let us come to the first one. What is challenged here? Narottam Rath case.
Here, your Lordship may kindly see the order of the ASO is under challenge, and if your Lordship sees the list of dates at page number B.
No, the Honorable Supreme Court has says that 12A appeal is there against the order of the ASO. So you have not approached the appellate authority?
We have approached the appellate authority.
Where is the order of the appellate authority?
Appeal is pending.
So
Appeal is pending.
where is that order of the appellate authority?
The order is appeal has.
What is the appeal number? What is the appeal number?
That we have not.
Ascertain that, and we want to know about the status of the appeal.
But in terms of the Honorable Supreme Court's order.
No, that is, if it is still no order has been passed in that appeal, as you say, then he has to take a decision on that appeal because the order is very clear that it is to be individually decided. So that is why exactly we want to ask you that if an order has been passed under Section 12 by the ASO and there is a appeal provision under Section 12A and you have also taken recourse to that appeal provision, what is the stage of that appeal, whether any order has been passed in the appeal or not? What is your instruction, Mr.
Can I apprise your Lordship of one point? Here there are two categories of cases. One which would fall under this, which falls.
No, you will, once it has been ordered that we will go individually, we will go individually. No question
The first case
Each
is
case will decide on its own merit.
No.
So the first case, we are putting a pertinent question to the state council. Where have you stated that you prepared an appeal and it is still pending?
That my lord can kindly see.
Which paragraph?
That should be paragraph I at page 5. Paragraph capital I. P capital I. Here the point is that the
No,
order
come, let us see that one. Three,
5 PI at page number 5 of the writ petition.
page number 5. Yes, which one?
Capital I, that would be relevant to mention that
Yeah.
against the order dated so and so passed by the opposite part, the petitioner on being ill advised has preferred an appeal against the aforesaid order and the said appeal is pending. It is submitted that in similar appeals, the appellate authority has issued so and so a copy of one
What
such
is the appeal number?
that we will
Ascertain that appeal number.
Right.
And it is pending before the opposite party number 2. So tell us the appeal number, we'll ask him to, can it be taken up tomorrow? You can just obtain the appeal number.
one time next week.
All right. Lekun. Period the order of the Honorable Supreme Court
May I
passed
just-
in so and so.
Just one thing I wanted to draw your attention.
Well, let us, the writ petition has been filed. In the writ petition, averments have been taken that against the order dated 31/5/2013 in objection case number 16409 of 2013 passed by the opposite party number 2, that is the Assistant Settlement Officer Khurda Camp at Bhubaneswar. The petitioner has preferred an appeal against the said order and the appeal is pending. However, the appeal number has not been mentioned in the writ petition. Let the Land and Counsel for the petitioner ascertain the appeal number put up this matter on 11th of February 2025. We'll thereafter proceed accordingly. One by one, we'll go on each case. Yes. This matter is to come along with short. So, जो एगुड़ा सब तो वैसे, है ना? हाँ, जांच.
So since life increasing. Actually, since more than 12 years now.
Item 16 can be taken up next week. 16.
60.
16.
ସେଟା ତ ରହିଲା list ରେ ଆଉ adjust କରିବାନି।
Order session.
ନାଇଁ ମୋ hearing ଟା।
Hearing.
We asked somebody to argue the matter today.
18.
By 18 and see
18 ତ ସେ ready।
radiation. You are ready, na? Oh, to you.
Next week.
Yeah.
Supplementary list, item number 1.
Admit.
Should I brought something to this Honorable Court, item number 1.
Yeah.
This is a case, he has applied from jail, but before applying, he has applied on 30/1/2025. Before that, on 6/1/2025, he has already filed an criminal appeal before this Honorable Court. So kindly verify the Baliguda case number 188 of 19. Judgment, Manoj. The appellant name is item serial number 2 in the judgment.
Hey, this registry should have supplied.
Right.
But they usually do it.
Yes, but not.
Out case ରେ ବି ଦେଇଥିଲେ ନା
You mean to say
Yes.
that
regular criminal appeal।
there are, as it
Six.
appears, 6 persons face trial.
Yes.
So what is the result of the judgment?
They have been convicted.
All of them.
Yes. In serial number 2, Kanhu is there.
ଉପରେ ଲେଖା ହେଇଛି ଗୋଟେ ଅଛି criminal appeal 49 ଆପଣ first page ଅଛି appeal।
Is complete.
Huh.
Connected to 49 of 20.
Yes. And there in serial number 6, Kanhu is the appellant, and this order was passed by this Honorable Court.
49. So who has filed that 49?
49, Mr. Debasis Panda.
No. Whether all the
Yes. Well, I have the copy.
Oh, we were going to appoint you in this appeal।
Sorry.
As amicus curiae, we were going to appoint you in this appeal, jail criminal appeal।
No, already.
Exactly।
filed.
ସହିତ list ଦଉନାହାନ୍ତି।
Yes, order. I am appearing for the informer.
Oh,
Fifteen, my lord. The wife of that.
okay, okay।
Section. So that means all of them, all the 6 persons have been found guilty.
Guilty.
Now,
ତାଙ୍କ ତ ସେଟା ଦରକାର ନାହିଁ।
this criminal appeal has been filed by all the 6.
This is the. I have received the copy of the appeal.
ବଢିଆ ହେଲା ଏଇଟା ତାହେଲେ ଆଜି dispose
ଦରକାର ନାହିଁ।
ଦରକାର ନାହିଁ ଏଇଟା କେବେ ଆସିଲା କିନ୍ତୁ ଚିଠିଟା।
Yes, Balaji Acharya Swanson. देखिए के judgment of
ଜଜମେଣ୍ଟ ତ ଏଇଠି ଅଛି ବ। ଆରେ ବାପା ତାର ଏଫଆଇଆର ଡିଟେଲ ଦେଖୁନାହାନ୍ତି ତ। 32 ଆଉ ଗୋଟେ
ଚରଣ ସାହୁ
ଆଉ ଗୋଟେ ଅଛି।
ବିଶ୍ୱଜିତ ପାତ୍ର କେସ୍ ବାଲାଜୀ ଆଚାର୍ଯ୍ୟ ଦାସ ବିହାରୀ ଦାସ ବାବଲୁ Swanson challenging the judgment ST 57 and certificate. And so,
ଏଫଆଇଆର ଡିଟେଲ୍ସ ବି ଦେଇଛି ଆର କ୍ରିମିନାଲ ଆପିଲଟା।
ସିଓର ହବା ପାଇଁ ଡିସ୍ପୋଜ କରିଦଉଛୁ ତେଣୁ ସେଇଥିପାଇଁ
ଦେଖିଦେଲେ କେତେ ଆପେଲେଣ୍ଟ 6।
Yes.
ଠିକ ଅଛି।
This is filed only by that Kanhu.
Yes.
This jail criminal appeal.
Jail criminal. That is on 31/2025.
So let us see that order passed.
After that order was passed.
This one is hard to admit. लिखी जंतु admit क्या लिखी हुई है। This JCRLA has been filed by Sahoo. This JCRL of 16 of 2025 has been registered on the basis of the prisoner's petition received from Sahoo, who faced trial along with 5 others in the court of Lion Sessions Judge Ganjam Berhampur in Sessions Trial number 57 of 2023, Public Sessions Trial number 58 of 2023 for offences punishable under section so and so and has been found guilty under section so and so. Regular appeal file କରିଛି ଆଉ ପୁଣି JCRL ଅଛି କି ପଠେଇ ଦେଇଛି ଗୋଟେ and has been found guilty under section so and so. Mr. Saubhagya Ketan Nayak, Land Council, submits that the Kanucharan Sahu
you have appeared for the
Yes, in that case, I have already appeared.
submits that appellant Kanucharan Sahu, along with other co-accused persons, have already preferred criminal appeal number 49 of 2025 before this court, challenging the self-same judgment and order of conviction, and the appeal has been admitted by order dated 13/1/2025. He has also produced the copy of the order which is taken on record. He states that in the said criminal appeal number 49 of 2025 is appearing for the informant.
Victim.
Victim, is appearing for the victim. In view of the submission made and the order passed in the CRLA number 49 of 2025, in which the appellant number 6 will dispose of this JCRLA number 16 of 2025. Accordingly, JCRLA is disposed of. This is taken on the surface. So they go to काम करिए कि जो इधर सब ना गुड़ा का ना अपील मेमो टा पर वो कॉपी कर प्रोसीडिंग है ना अपील मेमो रो कॉपी टा मध्य रखते हैं.
order to communicate with the
It's order be communicated to the appellant by the
Prisoner.
Land
Prisoner.
Council.
Welfare officer.
through the welfare officer से जो को prison दे.
Yes. There are copy के बाहर कोई होती है. Appeal memo.
क्या अच्छी था? आपको ये वाला नहीं थी.
चलो appeal
Court से appeal था.
appeal memo आमरो. No, appeal memo टे काढ़ी की नहीं. ये जो JCRL रे रखी दियो.
49 ଅଛି.
है ना? Yes.
49 ଅଛି.
Next.
Item 2.
दे दो xerox.
Right. Rakini Panda has already filed Nama. The name of other counsel shall not be reflected in the cause list henceforth. Yes, there is an application for bail. We want to move it today. ନାଇଁ ଆପଣ paper book କଣ paper book ହେଇଯାଇଛି?
ready ହେଇଯାଇଛି 2009 ର also.
Let a copy of the paper book be supplied to Ms. Mandakini Pandit.
Bail petition for early bail भी ଅଛି और hearing भी ଅଛି.
The offense which has been filed earlier, that is IN number 16 of 2019. ଗୋଟେ ତ ଅଛି bail ପାଇଁ
ନାଇଁ
early
ନାଇଁ
hearing
petition ପାଇଁ ଅଛି.
ଆଚ୍ଛା
କେତେ ଦିନ ଅଛି ଭିତରେ 20? Okay.
so matter be added to the hearing list. Are you ready? Will be ready next week.
One chapter.
All right. Put up this matter are been added to the hearing list. Be commencing from 17th February 2020. ଆପଣ paper book ଟା receive କରିକି ନେଇଯିବେ order sheet ରେ sign କରିଦେବେ 4 hour ପରେ ନେଇଯିବେ.
Item 3.
Yeah.
He was facing trial at Jasur. I contacted him and also contacted the authority. They tried the level between get 2 numbers of CVTs and their numbers and addresses.
Have you given them?
ମିଳୁନାହାନ୍ତି.
ମିଳୁନାହାନ୍ତି ତାହେଲେ କ'ଣ କରିବ?
Let us see what is the offense. କ'ଣ କରିଛି? ନାଇଁ ନାଇଁ previous ତ କରିଛି କ'ଣ?
No, the most of the why we adopted this method because in number of cases we after getting interim bail they just they didn't surrender and that is why in most of the cases it is found that the address is not correct. So बाकी जो surety एटी produce ହେଇଯାଉଥିଲା ସେଗୁଡାକ ବି ସେମାନେ just for the sake of money they become the surety. So these are the problems that is why we are passing the order to verify first whether the address is correct or not. And the second is that local surety ସେମାନେ ବି ensure କରୁଛନ୍ତି attendance କାରଣ ତାପରଠୁ ଆଉ ବିଶେଷ ସେମିତି କେସ୍ ଆସିନି ଯୋଉଠିକି ବେଲ୍ ହେଲା ପରେ ଫେରାର ହେଇଯାଉଛନ୍ତି ବାହାର ଷ୍ଟେଟର particularly. ତେଣୁ
He is not able to arrange. He is in custody since how long?
16 years. We have to take up the hearing only because paper book has been prepared. Paper book is like that. It is not. So we are directing the registry to prepare the paper book so that it can be taken up.
In the meantime, we will get the numbers of CVTs. Is there a trying mirror to
The London Council for the petitioner appellant
Pending.
seeks some further time to comply the order dated to produce the name, address, and documents to local sureties. Please this matter in the week commencing from 24th now this some other March 2025. In the meantime, since it is stated by the Land Council for the appellant that the appellant is in judicial custody for
16 years
for about 16 years. Let the registry prepare the paperwork in the meantime. Yeah.
Item 4.
Come to paragraph number 2. Paragraph 2 of the judgment where the
Constitution is related to 59. Take a look at about 538. So we have the information for provision. Then like that is the elder brother Ganga for asserting like the land near the house of Sarnati. The Srinathar was to be sought, but found the dead body of his wife. The hair completely sword from Peter. It alleged the Gangadhar Putta had to explode on his.
So eyewitnesses are there.
Yes, sir.
So you did expose and that head was completely severed from the trunk. Item number 1 so is an application for bail. The allegation against the petitioner, prosecution case against the petitioner is that he assaulted the deceased, was his sister-in-law. So, with a weapon of offense, X,
Yes.
as a result of which the head of the deceased was completely severed from the trunk. There are eyewitnesses to the occurrence. In view of the evidence of the eyewitnesses, so also the evidence of the doctor bracketry PW 14 conducted post-mortem examination for the dead body of the deceased, we are not inclined to release the appellant on today's next.
Item 5.
Custody since how long?
And the seventh one.
Time to put for a bucket.
They permitted the
The petition appellant is stated to be in judicial custody for more than 9 years. This to shall expedite the preparation of the paper. Yes.
Item 5.
And for me to not just one interlocutory application.
Wait, there is a like G এখন দিন।
এটা কোন পুনি পড়ে গেল এটি? Finding of the ground. তো আমাদের ছিল তো ঠিক আছে।
In the introductory application and claim for a interim bail. Nice of the present petitioner is going to marry day after tomorrow.
Which what you want to notice?
My lord, 1389 of 2020.
Okay, IA number 389 of 2022. There is an application for interim bail. Land Council for Land does not want to face this application. Disposed of as not faced. Yes, now.
320 of 2025.
କାହାର କଣ ବାହାଘର ହଉଛି?
Another ବାହାଘର ହଉଛି has to bride gift ceremony will be performed by the present petitioner. The petitioner is the uncle of the.
ଆପଣ ସେ ଯଦି ସେ ଜୁଇଁ ଜାଣିବ ଯେ ମତେ ମାନେ କନ୍ୟା ଦଉଛନ୍ତି ଯିଏ ସେ ଆଜୀବନ କାରାଦଣ୍ଡରେ ଦଣ୍ଡିତ ହେଇଛି ସେ ପଳେଇବ ବାହାଘର ଯଦି ଆଜୀବନ କାରାଦଣ୍ଡରେ ଦଣ୍ଡିତ ହେଇ କ୍ରିମିନାଲ ଅପିଲ ପେଣ୍ଡିଂ ଅଛି ସିଏ ମତେ ସେଠି ଆସୁଛନ୍ତି
ମାନେ ବାପା ଦିଅନ୍ତିନି ମାମୁଁ ଦିଅନ୍ତି।
ମାମୁଁ ଦିଅନ୍ତି ଯେ
Even I have annexed also in custody certificate of 4 times he has lived to his.
ଆଗରୁ ଯାଇଛନ୍ତି ବେଲରେ?
He has gone for some valid reason.
He has lived on leave
So
4 times.
what is the proof that your niece is going to be married? What is
My
the,
lord, I have annexed invitation.
This High Court has granted you interim bail.
No,
Tale?
from jail he has lived 4 times.
এটা তো ছাড় দিতে পারে
Not granted
পারলো দিতে
4 times. Around custody period is 11 years.
ଏବେ ବି ଥାଇପାରେ
ମଙ୍ଗଳା ପ୍ରସାଦ?
ବାହାଘରଟା ହଠାତ୍ ଡିସାଇଡ୍ ହେଲା ନା କଣ ଆପଣ 2 ଦିନ ଆଗରୁ
I have
ଆସିଥିବେ
been informed accordingly. I filed this application on 27.
ମାନେ ଶୁକ୍ରବାର ଦିନ ନା?
ମାନେ ଇଏ ଯଦି କଥା ତାହେଲେ ଆକୁ ଆଗ ପରମିଶନ ନେଇକି ତ ତାପରେ ଇଏ ହେଇଥାନ୍ତା ହଠାତ୍ ଗୋଟେ
verify for the authenticity of the original of the whole project.
ବାହାଘର ହଉଥିବ ବାହାଘର ଦରକାର ନାହିଁ ଏଠି କରି କାଲି ଦିଅନ୍ତୁ କାଲି କାଲି ଦିଅନ୍ତୁ
ସେ ଡିଷ୍ଟ୍ରିକ୍ଟ ପାଖକୁ ପଠେଇଦେଲା ସେ ତାର ଭେରିଫାଇ କରିବ ଯଦି ଠିକ ଥିବ ତାର ସେ ଦବ ନାହିଁ they won't accept it. IN number 320 of 2025, there is an application for interim bail on the ground that the niece of the petitioner is getting married on 7/2/2025, and the presence of the petitioner in the marriage ceremony is very much necessary as per the local customs. The marriage invitation card has been annexed to the interim application as annexure 2. You have taken instruction on this invitation card. It is Land Council for the state submits that he has not obtained instruction in the interim application. After hearing the Land Council for the parties and going through the amendments taken in the interim application, so also the document annexed to the interim application, we are inclined to release the petitioner on interim bail for 1 week, subject to condition that before accepting bail bond, the Land Trial Court shall verify whether the grounds taken through the grounds taken regarding the marriage of the niece in this interim application.
out of ground nature has been released earlier from jail.
Land Council suggests that petitioner has earlier been released on interim bail and he has never flouted the terms and conditions.
That is not correct.
He has not been granted.
ତାହେଲେ କହୁନାହାନ୍ତି
ଆପଣ ପୁରା କହିଲେ interim bail ଯାଇଥିଲେ ବୋଲି
He took leave the jail officer.
ଜେଲରେ ଗୋଟେ ଲିଭ୍ ଏମିତି ଦିଅନ୍ତି
ସେଇ parole ଯାଇଥିଲେ. So you have not been granted by interim bail.
No, I have not granted.
Submission ଟା ଯୋଉଟା କରିବେ ପୁରା କ୍ଲିୟର କରିବେ ଆପଣ ଯେମିତି କହିଲେ ଆମେ ଲାଗିଲ interim bail ରେ ଆପଣ ଯାଇଛନ୍ତି ଆଉ ତ
କୋଉଠି ଅଛି ଆପଣ ଲିଭ୍ ରେ ଗଲେ
Kindly see page 6 and 7 and 8.
admission
Even he has also obtained one jail reformation certificate.
ନା ନା ସେଇଟା ନାହିଁ କୋଉଠି କାଗଜ ଦେଖାନ୍ତୁ ମାନେ ସେ ତ ଭେରିଫାଇ କରିବେ ଜଜ୍ ଭେରିଫାଇ କରିବେ
verified to the IAC of which police station?
Vaidyanathapuर police station.
You are a man from Vaidyanathapuर police station. अच्छा ଆପଣ ଲେଖା ହେଇଛି ବଡ ବଜାର
ବଡ ବଜାର police station.
ଠିକ ସେ କୁହନ୍ତୁ your appeal address is PS is ବଡ ବଜାର.
ବଡ ବଜାର matter.
ପ୍ୟାରୋଲ ରେ ଯାଇଛ 4 times
ଏ ଯୋଉ ବାହାଘର ଯୋଉ ହଉଛି ଆପଣଙ୍କର ଯୋଉ ନିସ୍ ର ଏଇଟା କୋଉଠି ତାର ସେ କୋଉ ପୋଲିସ ଷ୍ଟେସନ ଏରିଆ?
ବଡ ବଜାର police
ସେମ୍ ପୋଲିସ ଷ୍ଟେସନ ବଡ ବଜାର ପୋଲିସ ଷ୍ଟେସନ The petitioner shall not indulge in any criminal activities while on interim bail and shall not leave the jurisdiction of the land trial court. Violation of any terms and conditions shall entail cancellation of interim bail. Get the certified copy and produce it. Next.
Item 6.
Mother of the petitioner is suffering from what is the report? Huh? Is a local man or outsider?
Local.
You have filed this application only for appellant number 1. Deva Maji.
Right.
ରିପୋର୍ଟ ଆସିଲା ଯେ ଆପଣ 25/10/2024 ଆଡମିସନ ହେଇଥିଲେ 27 ଆପଣ ଡିସଚାର୍ଜ ହେଲେ ତା ପରଠୁ ଆପଣ ଆଉ କୌଣସି ଜାଗାରେ ଟ୍ରିଟମେଣ୍ଟ ହେଇନାହାନ୍ତି ଆଉ ମ୍ୟାନେଜ ଟୁ ଡୁ ଡେଲି ରୁଟିନ ୱାର୍କ ଡେଲି
ଦେହ ଭଲ ନାହିଁ
ଦେହ ଭଲ ନାହିଁ ହଁ
ସ୍ତ୍ରୀ ଲୋକ ମଦର
did not sign. For years she has surrendered. He can be expected restitution. So,
ଜଙ୍ଗଲ ଭିତରେ ଗାଁ ଟା
so this was your mother, na?
Mother.
ଚିକିତ୍ସା କରି
ଆଉ ଚିକିତ୍ସା କାଗଜ ଆଣିକି ମୁଁ ଦେଖେଇବି
an application for interim bail filed by the appellant number 1, petitioner Deva Maji. On the is that IA copy?
IA 3012/2024 ସେଟା ତ
Again.
ନାଇଁ ନା?
3012.
ହଉ
On the ground that the mother is suffering from swans, order leakage. Now, the land council for the state was asked to obtain instruction. And today he has produced the written instruction received from IIC Pickle Police Station. It is 4/2/2020. And it also mentioned that the petitioner's mother was admitted in the hospital for ailment, and and she was discharged and she was referred to MKCG Medical College, CORAM for further treatment. It is further stated that her health condition is not well. However, she managed to do her daily routine work. And the father of the petitioner is suffering from visual problem due to damage to his eyes. And a Boroka pro Majiki from Ma.
ବାପା
Acha.
ନାଇଁ ରେ ବାପା
Bapa hଉଛି Boroka na has a visual problem.
ମା ହଉଛନ୍ତି ଅଳାଇ
The report is taken on record considering the submission made by the Land Council for the respective parties. The government taken the interim application and the report produced on. We are inclined to release petitioner on interim basis. On the date of release. Matter to be listed on such and such date. Land Council for the petitioner. Appellant shall produce the surrender certificate.
not writing କିନ୍ତୁ କଣ ଟ୍ରିଟମେଣ୍ଟ କଲେ ମାଙ୍କର ଆଣିବେ
The
Please, Your Lordship, I'm appearing for appellant number 8, Your Lordship. I filed an interim application pressing for interim bail, Your Lordship. The father of the appellant is ailing and the mother is
it was asked to obtain instruction on that.
No, no, no.
new
That's fine.
you filed
Yes, sir.
one for regular bail and one for interim bail
You
Yes,
now you want to place this application for interim bail.
yes, Your Lordship.
Ailing mother.
Mother is already paralyzed, Your Lordship. Father is now ailing.
ଆପଣଙ୍କୁ ଆଗରୁ ବେଲ୍ କିଏ ଦେଇଥିଲା interim bail
This honorable court, Your Lordship.
this ଯେ କିଏ
Your Lordship.
Who is honorable judge because
ସେଠି ଯିବ ସେଇ ବେଞ୍ଚ କୁ otherwise ଆରେ ଆମେ ଆଙ୍କୁ ଦେଇଦେଲୁ ଯେ ସେଟା ଦେଖିନୁ appeal
Justice S. Panda, Justice S.K. Panda.
your bail application was earlier assignment ଆପଣଙ୍କ reject ହେଇଥିଲା ନା bail ରେ ଯାଇଥିଲେ
interim bail ଦେଇ
Interim bail was allowed.
standing order ଟା ଆଣିଲେ କଣ କରିବା
standing order ଟା ହଉଛି reject କରିଥିଲେ ସେଇ bench କୁ ଯିବ
standing order କେତେ ସେଟା ଚଳେଇବୁ standing order ନା ମୁଁ କହିଲେ ହବନି ଦବାକୁ ପଡିବ ଅଛି ଅନଲାଇନ ଅଛି କାଢ
division bench ରେ ଯଦି
ପ୍ରଧାନୀ ଜାନି ନୁହଁ ସେଟା ତା ପୂର୍ବରୁ
division bench ରେ ଯଦି reject ହେଲା ତାହେଲେ
ସେଟା ମତେ ଲାଗୁଛି
subsequent bail application is pending then
dispose ହବ ତାପରେ ବିଦ୍ରୋହ କରିଦିଅନ୍ତି
it has to go to the same bench if it is available or if one of the judge should go to the
ବଢିଆ ହେଲା very good ହଁ good standing order number ଟା କହିଲେ
one of 20.
one of
20. Same bench if available, which has passed this one. If not available, then one of the group actually regular roster.
ଚଳିବ ଏଇଟା ହେଲା dismissing on merit withdrawn or not pressed ତ allow କରିଥିଲେ ତ କିଛି ଲେଖା ହେଇନି
It allow
ରାଜା ଫରୱାର୍ଡ ଫଟୋ ଅଛି
competition. So pretty good. So this appellant number 7's bail application was whether earlier rejected
No, Your Lordship, it was allowed, Your Lordship. Appellant number
Okay,
8.
we would have accepted.
allow it. Allow it na phone rabo. 8 होते से 8 नहीं.
तो standing order रे अच्छी ना.
Last 5. Refer with it. Oh,
Justice Dinas and
good ticket.
Just the application for interim bail shall be heard by the same division bench which has rejected the response. If on any of these orders available to response, member consider three vote preference. But once such application is decided by the regular bench, all the subsequent and same matters shall be read with the same bench. So we don't have shortly.
Disposal what done or actually to get done. You answer I might it has not been dismissed. The disposal what done already.
Bottom is
हाँ सेटा पर तापर इटा कर देला हम पड़ जाई है तो लेट दिन दैट डॉक्यूमेंट इटा को रेफर कर.
So you take instruction on that application, that IA which has been filed. What is that IA number?
IA number 397 of 2025.
Huh?
397 of 2025.
What ground you have taken here?
The ailment of the father, Your Lordship.
Where have you taken?
Lordship, paragraph 6.
Paragraph 6, please read it out.
That the petitioner has an ailing mother and is the only earning member of the family. In the meantime, the father of the petitioner is also ailing and suffering from severe muscle ache, so also other health conditions, and is under medication. Since the petitioner being the sole earning member is in custody, there is no male member to take care of the ailing parents of the petitioner.
So you have annexed the medical document.
Yes, Your Lordship.
So have you taken instruction?
no man.
All right.
Coming for the first time.
IA number 397 of 2025. You have received the copy of the interim application.
No man copy.
Connected criminal epilepsy. Bill 4620 arises out of the same trial.
ଦିଟା କା
And Cedar Bell reject his would appellant.
ପିଲାର ନାହିଁ ସେଟା କଣ
Nine money you are the counsel.
ଯୋଉଟା କାଉନସିଲ ସେଥିରେ ଯାଇଥିଲା ବେଲ ଇଣ୍ଟରିମ୍ ବେଲରେ ତାପରେ ସେ ଇଏ କଲା ଆପିୟର କଲାନି
Considering the submissions made, this court is not inclined to enlarge the appellant on bail.
ଆଉ ଥରେ ଏନଲାର୍ଜ କରିଥିଲି that was rejected.
We are not in on history hela we are not interested. So standing on order on the reject hithele we can't entertain. So they are attack the reason.
ସେଟା ହଉଛି ଯାଉ ଭାରି ଛୁଟି
Here
ସେଟା କାଟି ଦିଅନ୍ତୁ ଖାଲି ଲେଖି ଦିଅନ୍ତୁ IA number since it appears that in the connected criminal appeal number 46 of 2020 the bail application has been rejected
in respect of appellant Pushpamaji.
in respect of appellant Pushpamaji by division bench of this court. Let the registry obtain appropriate instruction from the Honorable Acting Chief Justice. The matter be placed before the appropriate bench here for the. Yes.
Vijay Mr. Das, that also won't be proper. Once it is assigned, it is all right. It's not pointed out. Simple consider is taken on record.
Photo.
That is taken on record. Instruction taken on record.
जो मासे हमें जो बेल ये जो मासे बेलटा जोटा we are recalling that and recalling माने
we are not सेटा खाली instruction taking on record and then appropriate bench जो ठीक है.
Item 7.
May I please? Milord, kindly have a glance. Order dated 25/11/2024. Your Lordship directed to the State Council to
First, you say, has your bail application been earlier entertained, allowed or dismissed or anything?
Yes, yes, during the COVID period, your Lordship granted 1 month granted by interim bail, and that has been thereafter surrendered the present petitioners during the course of COVID-19.
Okay. ଠିକ ଅଛି, ଆଗକୁ ତାକୁ-
So no criminal antecedent and 2 minor debtors are there.
1 minute, wait, ଟିକେ ରୁହନ୍ତୁ 2 minute.
Now, bail application not placed.
Not press. ସବୁ ଗୋଟେ ଗୋଟେ କରି ଦେଖିବାକୁ ପଡିବ। ନାଇଁ, dispose ହେଲେ ବି separately ପଠେଇଦବ।
This is the second successive interim application filed by the appellant. Whose earlier interim application for bail.
ସେଟା ବୋଧେ regular. ସେ ଯୋଉ first ଟା, ଏ ଯୋଉ
Ah, see.
24/9 ଟା।
Bail through. This is
interim.
second, it is interim bail.
ନାଇଁ ନାଇଁ, earlier interim.
Earlier in bail application IN number 1543 of 2022 has been disposed of as not pressed.
Dismissed.
Dismissed as dismissed कर दिया। Another division bench that after instruction will be taken by the registry and the development that the Chief Justice matter be placed to yes.
Item 8.
Grant ହେଇଥିଲା।
Passed by the common sessions of Sana and lifted the under section 302 01 to 97
Disposal ଲୋକମାନେ ହଁ ଗୋଟେ particular one clear sure ତାପରେ କରିବ।
Clarify
Then these two one not taken into consideration.
and lifted the under section 303
କିଏ handle ଦବା କଥା।
97
ଟିକେ ଆଗରୁ ଟିକେ କହିଦିଅନ୍ତୁ, ଆଗରୁ not rejected first application।
the application filed for
ଦେଖିବାକୁ
no
No, just a minute. IN number 2003 होची of 23 होची bail. अपन करो। This is item number 7 तो?
8
JCRL number 18 of 2023. IN number 28 of 2025. So, you that earlier your bail application has not been disposed of.
elections region custody 10/7/2017.
We are not on that.
More than 6.
Yeah. Since when you were in custody?
10/7/2017. Arrested on 8/7/2017.
Neither is the man of outside of the Pradesh.
Belongs to Madhya Pradesh.
Verification of he involved in also in another case. All right. Take instruction about the verification of
Division and criminal antecedent.
IN number 28 of 2025 is an application for interim bail.
Antecedent.
There is involved in another case.
394 302.
302.
No, it must be this one.
Holding so the previous case number.
ନାଇଁ ଆଉ ଗୋଟେ
ଏଇଟା ଆଉ ଗୋଟେ
ଏ ଆଉ କଣ?
and the case has been charged with
ସେଟା କଣ ହେଲା କେସ୍ ଟା ବୁଝନ୍ତୁ ଟ୍ରାଏଲ ଚାଲିଛି ନା କଣ ହେଇଛି ଆଉ ଛାଡ଼ିଦେଲେ ସେ ଟ୍ରାଏଲ ଟା ପୁଣି ଉଠିଯିବ ସାର୍
and is submitting response accounts is involved in further case number 351.
ନା ନା ଗୋଟେ 351 ଗୋଟେ 225 55 କଣ କହୁଛନ୍ତି ଆପଣ
ତା ପରଟା ତାକୁ ମିଶେଇ ଦିଟା ଦେଇଦଉ ସେଟା କନଫ୍ୟୁଜନ 255 ଗୋଟେ 355
କୋଉ ସଦର ଢେଙ୍କାନାଳ
trial court record ଢେଙ୍କାନାଳ
ଟ୍ରାଏଲ ଏଇଟାର କେସ୍ କେତେ
ଏଇଟା PS case ଏଟା ହଉଛି Mr. Mahi. It is the same case in which the charge sheet number is 255 and that is dated 19/9/2017, the very case that would be available from the final form. That final form.
394 ଗୋଟେ ଥିଲା ଅଫେନ୍ସ ଟା
Final, that is 394 ଅଛି. ଏଇଠି
ଚାର୍ଜ ସିଟ୍
click the final form. Trial court record.
ହଁ ଦେଖିଦେଲା Have you verified if it is the same case?
ଏଇଠି ଜଣା ପଡୁଛି. Case 24.
ठीक है मिस्टीरियसली लिखिक दउछन से
That's it. So what is the case of the prosecution?
Onion from Madhya Pradesh and today as a finisher. Return after selling this onion, he taken up rupees 34,500 and there is a dispute between the driver of the ships and the accused person's ownership. Thereafter the
So what are the evidence on record?
given eyewitness will also
Eyewitnesses are there?
no
No eyewitness.
no eyewitness.
So what are the circumstances against you? No, what are the circumstances? Let us say extrajudicial confession, last seen, this, that. So we just want to,
Last scene, both were driver and helper,
driver and helper.
carrying with the onion truck. After disposal,
Who
returned
is
with
the,
money.
who died?
Driver died.
Driver died. What is the name of the driver?
That is
Both of you came with the onion in the truck. After the onion was sold and the money was received, you killed the driver and took the money
in the middle of Tenkana. They have
and threw the body.
Prakash Pawar is the deceased. And this man is the helper. So they were seen together by PW. Who has last seen them? Yes, Mr. You said that last seen PW7. PW7 has not stated anything about it.
Yeah, yeah,
Preparation for court conduct. PW7 is Manas Nayak. He has stated that I know the accused. I was working in a restaurant. In the morning hour, the accused came in a truck. I instructed him to park the truck at a distance on the road so that the restaurant would not be blocked, road to restaurant, and accused was alone in the truck. Then he parked the vehicle and went away. That's all he has stated.
His last scene with the truck.
Last scene को दिखा, कहाँ
Last
से
scene
last?
with the truck.
What is that last scene with the deceased?
Circumstances, how is the trial court
When
discussed?
any circumstances has been formulated that these are the circumstances in the trial court judgment,
ଦେଖିଛନ୍ତି କୋଉ page?
क्या रखी थी? Sorry. The bail application in a 302 where life imprisonment is there in the highest court, and this is your preparation. You are being watched by others because it's live streaming. They are watching your performance.
Defense has elicited from the mouth page 17.
Where is
If you
the
are asking a pertinent
circumstances?
question, what are the circumstances if it is not a case of direct evidence?
Eleven. 15, paragraph 11. Not sure.
If there is no direct evidence.
The telephonic talk they have 30. The hot shot telephonic talk that received with Rakesh. He was then present with Rakesh at the relevant.
Just read that paragraph number 11 से जो मौजूद. Two, there is no direct evidence. Read out. Paragraph number 11, page number Ruchi 15, internal page 15.
Prosecution alleged. So there,
Yes.
prosecution alleged that the accused in his case was the author of the same homicidal death of the deceased. That this accused, after having committed the of the deceased, subsequently threw the dead body of the deceased on his way ahead inside a bushy forest near Denkanal in order to cause disappearance of evidence of commission of such murder with the intention of screening him from the legal punishment, and that the accused committed robbery of 34,500 from the deceased using MO1 and thereby attempted to cause the death of the deceased. True, there is no direct evidence in this that this accused committed the murder of deceased and that they threw the dead body at the spot where it was found laying, or that he committed robbery of the apostate case by attempting to cause the death of deceased. Be that as it may, there is direct evidence PW 9, 10, and 13 that the deceased was the driver of the deceased truck in Cochin and the accused was its helper. Evidence also indicates that on 14/9/2016, this accused, along with the deceased driver, after having loaded onions in that truck from Indore, came to Bhubaneswar for delivery. And after unloading the onions, the deceased received 34,500 towards sale price. Their evidence further reveals that the deceased telephoned Rakesh Power, the son of the owner of the truck, in respect of received 34,500 from the vehicle, from the vending. Instances of the accused to give him money for the purpose of drinking liquor, picking up quarrel with him, and giving the threat to him for his not obliging the accused. In transfers from their evidence that Rakesh advised the deceased not to part with any money with the accused. They have claimed that this accused killed the deceased driver subsequently, leave the dead body of the deceased inside the jungle near Denkanal. and fled away along with the truck and eventually left the truck on the way and decamped with the cash received by the deceased from the vending. All these witnesses have been cross-examined at length and nothing
So
material.
mainly relying on these three evidence,
Yes, not
that is 9, 10 and 13.
Yes.
Let us come to that 9, 10, 9%. On 9, read out
The deceased in this case, namely Prakash Pawar, is my brother. He was driving a truck bearing the return of such and such. I know the accused Lakhan Bodde. He was the helper of truck. On 14/9/16, the deceased along with the accused Lakhan loaded a truck of onion in the truck from Indore, Ujjain to Bhubaneswar. On 17/9/16, the deceased unloaded the onion at Bhubaneswar. After rolling the onion, he got 34,500 towards the price of onion and he telephoned Rakesh Pawar as regards receipt of 34,500 and further informed him that the accused was insisting him to give money to drink liquor. The deceased did not oblige accused Lakman. He further informed that the accused was picking up quarrel with him and threatened him. Rakesh told the deceased not to part any money to the accused. On 18/9/16, Venkanar police informed me that the deceased who have been murdered. On getting such information, I along with Banwarlal Pawar.
This is not this thing he has no knowledge about, direct knowledge. This he has heard.
Only it is 10 kouchi. On 17/26, they unloaded the onion from the truck, and after unloading the same night, Rakesh telephoned me. Saying that accused was threatening and insisting him to bring liquor. So that can infer
Koda?
10, PW10, DW10.
No, 9 तो 9 no किसी नहीं
10 रे कहूची जोटा
PW10 हाँ सुन
para 2. On 14 he is the owner of the truck. I am the owner of the truck bearing such and such. He was related to me as a nephew. He was driving my aforesaid truck. I know the accused in the truck. He was working as a helper in the truck 20-25 days prior to the occurrence. On 14/9/16, the deceased and the accused left for Bhubaneswar to their truck, loading onion for delivery at Bhubaneswar. On 17/9/16, they unloaded onion from the truck, and after unloading onions in the same night, Rakesh telephoned me saying that the accused was threatening and insisting him to bring liquor. In the same night, the accused killed the deceased and the driver. On getting information from Dukan
driver. The भाई होची deceased Prakash.
Paragraph 2 रे देखला राकेश वाला ऑनर
What is the name of the deceased होची Prakash, right? या ना होची कोण? Petitioner ना होची Lakshman.
Even Koti, the accused confessed to me before.
Go to one after another.
I'm not the owner of the truck. I'm not the owner of the truck. Or looking after that.
Rakesh होची की है?
I'm not the owner of the truck.
Inform me that accused was threatening and insisting him to bring liquor. एटा होची राकेश ताकू जणेला. राकेश एग्जामिन ହେଇची.
राकेश जणेला ना प्रकाश राकेश को जणेला ए लोकटा सुनिला.
राकेश टेलीफोन मी.
हां.
So he has also no direct knowledge about the incident, whatever he has heard from Rakesh. So Rakesh, बाकी ଆଉ ଗୋଟେ witness କିଏ ଆସିଲା? 13 number से कौन କହୁଛି?
11
नहीं 11 नहीं. ଆପଣ ट्रायल कोड रिलाय କରୁଛନ୍ତି 9, 10, 13.
ଖାଲି କହୁଛି accused confessed the same before me.
जहाँ भी information देइची deceased that the accused was demanding money to take liquor, ହେଲା, that was given to Rakesh.
11 confession ଅଛି ବୋଲି ସେ କହୁଛି police
Give it to Rakesh Pawar. Has he been examined as a witness?
No.
No. How this thing would be admissible? ଅନ୍ୟମାନେ ଯିଏ ବି କହୁଛନ୍ତି ଏଇ ଯୋଉ 10 ଆଉ 13 ଏମାନଙ୍କର ସବୁଙ୍କର ଭର୍ସନ ହଉଛି ଯେ ରାକେଶ କୁ ଆମେ ଶୁଣିଲୁ। Okay. The vital witness to whom the deceased at least intimated. ଏମାନଙ୍କର ଡାଇରେକ୍ଟ ମାନେ ସେ ବିଷୟରେ ଜ୍ଞାନ ନାହିଁ, ଯୋଉ threatening part ଟା ଯୋଉଟା କହୁଛନ୍ତି ନା ରାକେଶ, ଏମାନଙ୍କର ଜ୍ଞାନ ନାହିଁ, ଏମାନେ ଯାହା ଶୁଣିଲେ ରାକେଶ ଠୁ ଶୁଣିଲେ। ରାକେଶ ତାଙ୍କୁ 3 ଜଣ ଯାକ କହୁଛନ୍ତି
son of the owner.
ହଁ, son of the owner. So the source of knowledge is Rakesh. Why have you not examined the Rakesh? If he is not examined, then ये जो threatening aspect है, आउ तो किसी नहीं, बाकी इसे one is that they left together within a truck to Bhubaneswar carrying onion from Ujjain. All right. Then the that was unloaded at Bhubaneswar, and amount of rupees 34,500 was received by the deceased towards transportation charges. Okay. ତାହାପରେ ଯୋଉ ଘଟଣାଟା ଆସୁଛି ଯେ ତାକୁ ଧମକେଇଲା, ତାକୁ କଣ ଟଙ୍କା ମାଗିଲା, ଧମକେଇଲା ଏ ମଦ ପିଇବା ପାଇଁ, ଏଇ ଜିନିଷଟା ତିନି ଜଣ କହୁଛନ୍ତି ଆମେ ରାକେଶଠୁ ଶୁଣିଲୁ ବୋଲି।
confession ଅଛି ବୋଲି ସେମାନେ କହୁଛନ୍ତି 11 କହୁଛି accused confessed before the accused about the offense.
PW 11. Let us see that.
Confess this should be clear.
Yes, just a minute. That you see that next in the cross examination first line, at the time of making the accused was under police custody at Saikeda police station, Dhenkanal. So this is not the police custody, that is again. So how can it be relied on? So the only thing remains is the last scene. बाकी ये confession जीवो, ଆଉ ସେ ଯୋଉ threatening ଟା ଯୋଉଟା ହଉଛି, ଯେହେତୁ ଆପଣ examine କରୁନାହାନ୍ତି କେସ୍ କୁ, ସିଏ ଯିବ, ବାକି ଏତିକି evidence last scene ରେ ଅଛି, ଆଉ କଣ ରହିଛି ତବେ?
Son power, the another son, whose place 13. Okay. Trial court reliable, he has examined.
କିଏ PW
13, the son of the
ହଁ,
owner.
PW 13 ପୁରା ପଢିଲୁ।
ନାଇଁ ସେଥିରେ ସେ କହିଛି ମୁଁ ପ୍ରେଜେଣ୍ଟ ଥିଲି ବ୍ରଦର ରାକେଶ, ସେତେବେଳେ ସେ ମାନେ ଡିସିଜ୍ ୱାଜ ଇନଫର୍ମ।
Please come to PW 13.
I know the deceased Prakash Pawar. In this case, he was my cousin. He was driving the truck bearing such and such, belongs to Banwarlal Pawar. I also know the accused Lakhan Godde. He was working helper in the above plot. On 14 and 16, the deceased along with the accused left the Bhubaneswar with the opposite of carrying onion from Jain. On 17 and 16, the deceased unloaded the onion at Bhubaneswar and informed my elder brother Rakesh.
ହେଲା
Bawari, nahi, the present plan ତଳେ କହୁଛି.
yes
Rakesh that he accused was demanding money from him to take liquor. The deceased did not oblige him. The deceased also received 34,500 for transportation charges from the vending.
these are all information given to
नहीं ये कुछ का तौर खाली कही जे राकेश से जो प्रेजेंट करले I was present it look like deceased. I was present with my brother Rakesh and became our asking money to the accused and giving him threat to kill deceased. They are both accused and deceased left Ujjaini. Ujjaini living Bhubaneswar. On the way the accused killed the deceased. The years after the power has been the Gulshan power examined. That also informed that both you were traveling together and on the way you are demanding on to pay that money has killed.
you are in custody since when?
10/7/2017.
You are a local man or outsider? Ujjain.
Have you brought instructions?
That address is correct.
That's a verification is offered from the inception. The address verification was paid for at the outset. If a man of Andhra Pradesh.
You have not yet obtained it. You
No,
have
no,
not
not-
yet obtained instruction.
No.
Get that instruction.
ଆଉ ଇନଫର୍ମେସନ ମାଗିବ କି କେତେବେଳେ parool ଫରୋଲ ଯାଇଥିବ ଫେରିକି ଆସିକି
ये तो पहले जाएंगी custody
jail
certificate
certificate.
custody certificate and the during course of the hearing of the bail application the land counsel for the petition appellant submitted that the appellant is in judicial petitions 10/7/2017. The land counsel for the state submitted that the petitioner is a man from Madhya Pradesh and he will be given some time to obtain instruction as to whether the address as mentioned in the judgment is correct or not. Address of the accused person. Address of the appellant as mentioned in judgment is correct. Put up this matter on such and such date. Instruction regarding address verification to be obtained. So also we will produce the custody certificate. Custody certificate ଆଉ ଦିଟା କରିଦେବେ matter we placed ଗୋଟେ ସପ୍ତାହ ପରେ ଆସିବ ଆପଣ
1 week ରେ verify କରିଦେବେ ତ ତାର address.
To SP
superintendent of police communicate କରିବେ the superintendent of police
2 weeks
ढेंकानाल
out. 2 weeks.
होला the superintendent of police ढेंकानाल shall make necessary communication with the superintendent of police Vaitul in the state of Madhya Pradesh in that respect. Hala? Free copy of the order. Yeah. Three सप्ताह पहले 26
Item 9.
26 Yes.
Same judgment. In this appeal number 663/24, I want to place the bail application in this application. So the man of 64 years, my lord, and already 9 years and 1 month in the first year.
Who appealed that 663.
Vishal Mahanti.
This one, ma'am.
Yes.
Offense level, trial offense 351, 294, 323, 324, 323, 307, 302, and 34 of that. So actually the case here, FIR and counter FIR, they are concerned between both the informant as well as the accused my lord. In the meantime, during the course of the treatment, one of the person died.
So there must be eyewitnesses to the order.
One eyewitness.
Who is that eyewitness?
PCR. So judgment manner.
Deposition copy ନାହିଁ ଆପଣ ଦେଇନାହାନ୍ତି ଆପଣ ଦେଇନାହାନ୍ତି ଆପଣଙ୍କର ଅଛି ନା ନାହିଁ ତ ପେନ୍ ଡ୍ରାଇଭ୍ ଟା ନେଇଯାଆନ୍ତୁ the Land and Council for the appellant so also the land 663 of 2024 the land so the appellant so also the Land Council for the state submit that they are not having the deposition copies. Let the registry supply the deposition copies of the witnesses the respective council in their pen drives. Pen drive में नहीं है ना आरो सप्ताह रखिवा ना गोटे सप्ताह पर 1 week after that 17th February 2020 yes
Item 10.
But in my filing some deposition copy, I've already filed it.
no you give your pen drive to the Land Council for the petition appellant submits that the deposition copies of the witnesses examine DW agent PW agent from the side of the prosecution so also the from the side of the defense supplied to him. You are having that those copies deposition copies.
Yes. And the notice has been served out.
Let the registry supply the deposition copies in the pen drives to the of the appellant and Land Council for the notice ଯାଇଥିଲା which order no see the report has is already ଲେଖା ହେଇଯାଇଛି order dated 23/12/2022 no further order.
Letter minutes.
Yes.
Just to bring your lordship's kind notice minutes. We've got a letter from the informant that he is unable to appear because of his poor
No,
status.
the order mentioned that she wished to be defended by the public prosecutor.
Yes, that letter we have received.
ଆପଣ ଅଛନ୍ତି ଆପଣ
Yes, that is that.
Opposing the bail na kon lekha
Yes, for opposing.
ଠିକ ଅଛି ଆପଣ ଅଛନ୍ତି yes next
Item 11.
how many appellants are there
Only one minor. So the other appellate during trial she was dead by now.
no this is a regular appeal
Yes,
and it has been filed by Kushibas Sabha.
Yes, madam.
No, why we put the question to you, we find that there are 2 interim applications for bail.
I know the previous bail was filed by the case council.
So you are to not press that application. What we all right. So the IN number 1698 of 24, we are not pressing it because
Yes,
you are to not file it. IN number 1698 of 2024. This is an application for bail. Land Council for the appellant doesn't want to press this application as she has filed a fresh bail application. According to IA, is dismissed off as not pressed. IN number 1698. That's all. Baki tana 2842 of 24. How phone?
Since 24/6/2014 by now.
24/6/2014. Okay.
Actually, there were 2 applies by now. The father and mother of the deceased by now. Mother, she died by now during trial period by now. Now this is the sole.
Yes, in the judgment of the Land and Trial Court also it appears that one accused is there.
Yes, madam.
Yes.
During trial period, madam, the other.
Right. That is all right. So come to the prosecution case which is narrated in paragraph number 2 of the judgment.
Prosecution case in brief is that on 26/6/2014 at about 10 a.m. the S.I. Kadambani of Bodan case presented a written report before the case alleged that On 16/6/2014, she took up inquiry of Bodal PS UD case number 6/2014, dated 16/6/2014. During which she examined the informant witnesses, visited the spot, held an inquest over the dead body of the deceased Kumari Gitanjali Sabar, presence of the witnesses and her relatives, and sent the dead body of the deceased to CSC Boden for postmortem examination through escort party. While holding inquest, the plastic ligature mark was found on the neck of the deceased, having its knot towards right. Neck was swollen, bodily liquid was coming out from mouth, tongue was bitten, having marks of injuries on the right hand and abdomen, and there was discharge. Though the inquest witness Sri Ramnath Panda, while his opinion that the cause of the deceased was due to suicidal handling, but the EO could not reach at any conclusion as to the cause of death of the deceased. She had maintained the cause of death of the deceased as not known. During the course of inquiry at Vijay Tara and other witnesses, she examined voice Rishikesan Vishwar, the ex-sarpanch of local GP, who stated that on 16/6/2014, in the morning at about 10 a.m., the parents of the deceased named Sabar and Harabar, who has died on the ground, stated before him that due to questionable behavior of their daughter Gitanjali, the villagers were criticizing them. Out of sudden provocation, they assaulted their daughter on 15/6/2014 morning and poured boiling water on her. As the deceased Gitanjali became senseless, they strangulated her to death by means of a plastic rope. She examined Sapuru Sabar, the stepmother of Prithviva Sabar, who stated that on 15/6/2014 in the morning at about 8 a.m., she was present in the house of Priyocana Sabar close to the house of Prithviva Sabar. Prithvasa and Haramani picked up quarrel with their deceased daughter Gitanjali, assaulted her by means of a piece of wooden and poured boiling water on her.
Okay, so eyewitnesses are there.
No, my eyewitness, my lord. They are one son, my lord. These are
Eyewitnesses ଅଛନ୍ତି ନା ନାହିଁ ଏଠି? Whether anyone has been examined as eyewitnesses to the occurrence?
No, my lord. According to these version, my lord, he was present at the time of quarrel.
He has not seen the assault.
No, my lord.
So no eyewitness.
No, my lord.
Yes, Mr. No eyewitness.
W5 says that he was there at the present and he has seen that.
Assault देखी थी?
What's it?
Let us go to the PW.
W5.
On factual aspect, there should not be any controversy.
W5.
Please place that.
Paragraph 2, my lord. It is a fact that I was examined.
See, he has been declared hostile.
Yes, my lord.
Yes.
Yes.
Yes. The accused is my father. Harabati is my mother. Gitanjali, since dead, is my elder sister. About 2 years back, my father killed my sister. I had not seen the incident. Police Babu recovered a split wood. Then para 2 minutes. It is a fact that I was examined by police. It is a fact that I stated.
ସେ ପୋଲିସ ପାଖରେ ଏଇଗୁଡାକ କହିଥିଲା ବୋଲି କହୁଛି କିନ୍ତୁ ସେ କହୁଛି ଯେ ମୁଁ ଘଟଣା ଦେଖିନି.
Well, in the last time he said that my mother advised me not to disclose the matter to anybody.
Yes.
Well, I saw that my sister was dead. On being asked by my mother, told that my father.
ଏଗୁଡାକ ସବୁ ହଉଛି it is a fact that I stated to the police. ସେଇଥିରୁ ଯାଇଛି that ଲଗାଇକି ଏଗୁଡାକ ସବୁ ଯାଇଛି. ଆଉ ଥରେ ପଢନ୍ତୁ. It is a fact that I stated to the IO that on the date of occurrence there was a quarrel, that my sister assaulted so and so, that my mother complained so and so, that my father. So ଏଇଗୁଡାକ ସେ କହୁଛି ତମେ ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ପଚାରିଲେ ତମେ ଏଗୁଡାକ ପୋଲିସ ପାଖରେ ଏମିତି କହିଥିଲ ସେ କହିଲା ହଁ ମୁଁ କହିଥିଲି ନା but he କହୁଛି ଯେ I had not seen the incident. So that means whatever he has stated, that is 161 statement. It is not substantive piece of evidence. Fact remains that in court he has stated that I had not seen the incident. So how can he be an eyewitness to the occurrence? Because law is that even if you say that I hated before the police like that, that would not be an admissible piece of evidence because whatever you have stated the police, it is a 161 statement. What you state in court is that I had not seen the incident. Hala?
Everybody says mothers by spirit of
So if this evidence goes, then what remains? What are the other evidence? 17.
Yes.
conducted the postmortem report.
No, that is there. The death is as per the report of the PW 17. He has seen the lacerated wound and abrasion also seen, ligature mark he has seen.
Yes.
And there were blisters so and so. Cause of death might be due to constriction of the so and so. So homicidal death is there.
Yes.
So homicidal death is proved. So how the deceased is related to the petitioner?
This is the daughter of the appellant. This is the daughter of the.
Yes, she was suspected to be having an affair with somebody.
That they assaulted her and poured boiling water and.
No. Question is that what is the evidence? You are narrating the prosecution case story. We have to go by evidence, not by the prosecution story. So how far you have proved your prosecution case?
So PW 19 is the IO was
Yeah.
there is extrajudicial confession. PW 19's
What
and
confession?
leading to discovery.
So leading to discovery is admissible for
Yes.
that part only. It's not that that confession will be admissible. So much of information which led to the discovery of that particular weapon of offense. That is a wooden plank.
Yes.
So one wooden plank was recovered at the instance of the appellant. So that is one piece of evidence.
Yes.
What else is there? So
PW 3, 4, 5, 6, and 10 and 11.
everybody has shown hostile.
All of them have.
All of them have shown hostile. In custody since 2014. 24/6/2014. Had the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submits that the petitioner is in judicial custody since 24/6/2014. And the witnesses have not supported the prosecution case, and the evidence is leading to discovery of the wedding plan at the instance of the appellant, which is deposed to by the IO bracket PW 19. The Land Council submits that in view of the available material on record, there are good chances of success in the appeal, and balance of convenience is in favor of the appellant, and therefore the bail application may be favorably considered. Learned Counsel for the state, on the other hand, placed the evidence of PW 5, who though in the chief examination stated that he had not seen the occurrence, but stated to have after being declared hostile, stated to have given statement before police that he had seen the assault on the deceased. My father assault, he had seen the assault on this. Considering the submission made by the land and council for the respective parties, nature of evidence adduced during trial, absence of any direct evidence, and the period of detention of the petitioner in judicial custody, and also absence of any chance of early hearing of the appeal in the near future, since it's a criminal appeal of the year 2024. We are inclined to release the appellant on bail allowed. Sterilization of fire. Yes.
Item 12.
Well, just now I received the deposition copy of the deposition.
IN number P123 of 2024 is an application for bail. Land and Council for the state submits that he has just received the deposition box from the Land and Council for the appellant, and he may be given some time to go through the same. Next week, Rasivo, release this matter in the week commencing from 10th February 2025. Yes.
Item 13.
तो नंबर बोली
Item 13, my lord. Last week, my lord, to issue the notice to the victim, my lord. Call for the report, but my lord, we had not received the call for report. I just thought
the Land and Council for the state submitted a lucky IN number P280-2024. The Land Council for the state submit that he is yet to receive the report from the concerned police station, concerned IAC government, regarding service of notice on the victim public informant, and the matter may be taken up the week after for those. Release this matter in the week commencing from 17th February 2025.
Item 14.
Lordships, my lord, in this matter, I am through BC. We have filed a CRL MA, criminal miscellaneous application for the restoration of my appeal, lordship. It was dismissed in default. Now, to appreciate that there is no deliberate delay from my side, lordship needs to see the 5 order of this honorable court. That is order number 23, first of all, dated 27/8/22.
Restoration of CRL number 286.
Yes, lordship. 16. It was a case of 302. The appellant died during the appeal.
In the meantime, put legal aid of the appellant to come to notice issued to the doctor. Non-appeals to answer in time was granted. Another chance was given to the doctor and submitted. So what do you say, Mr. Manohar? The
yes, lordship.
So obviously,
no, my lordship. Just need to see. Lordship.
394.
My lordship, I will explain it. Lordship, kindly see the order number 23 of this court, dated 27/8.
Dated 27 or order number 27?
Yes, lordship. No, lordship. Order number 23, dated 27. Yes, lordship. We have informed this honorable court.
Where is the order?
Para 3. Mr. Pradhan, learned counsel for the sole appellant submits that in the meantime the sole appellant has died.
Which order you are placing?
Lordship, order number 23, dated 27/8/2020.
Which page is the order?
Lordship, it will be in the file, judicial file. We have only an. Yes, lordship. That file order.
26, order number 23.
Order number 23.
Just a minute. बेटा खोलो नहीं किसी और को।
Here है तो नहीं है।
नहीं आई थी ना। जब रही थी उसमें, कुछ हो गया।
वहाँ पेज है और ठीक है ठीक है।
My lordship. May I read it?
इसे तो देखिए ना।
Yes,
May I read it,
order
lordship?
number 23 and
3,
date is
para 2.
27/3/22.
Yes, lordship. Yes, lordship. Para number 3. Mr. Pradhan, learned counsel for the sole submit that in the meantime the sole appellant has died and his legal heir are interested to apply for substitution and pursue their appeal. List this matter and so and so on date. Lordship, now please kindly see the next order. Order number 24. It's my misfortune that my learned lawyer also died. It's in the para 2. Next order. On the last listing, Mr. So
legal years notice serve additional affidavit notice notice on 24/9/2020.
Yes, Lordship. On the last listing, Mr. Satyavrata Pradhan, the council had submitted that he had instructions to appear on behalf of the legal heir of the sole appellant and paid for some time for implementing them as the appellant in the place of deceased.
Yes, so
Accordingly, the case.
to be asked the information to be supplied to the daughter who had filed the affidavit.
Yes, Lordship, but no information came to our knowledge, Lordship.
So sufficiency of notice was there. In spite of that, nobody turned off.
Lordship, a very honest submission I have that we never found any notice from the court.
Now this CRLA has been by whom?
By the daughter, Nalini. We just want to pursue the appeal because of the two reason, Lordship. The impugned order is completely bad in law. If your Lordship will see only 2 lines of the impugned order. Only one person, that is me, was charge framed under section.
Don't go to the merit. We are asking you a question.
Yes, Lordship.
That twice the matter was the notice opportunity was given, and since no step was taken, the appeal abated. Now who has come up to file this CRLA?
Daughter of the
appellant.
This is
yes, Lordship. She is the daughter, and in next order, my lords.
Now the this judgment was in what way it would be helpful if it is restored and heard?
Fine impose.
Yes. No, Lordship. There are 2 ways. First of all, the trial court judgment is bad in law.
No, question is that he is the person, your father has.
Yes, Lordship.
This
we are agreed person.
Trial under 302, and
yes,
he was found guilty, and now he is dead.
Yes, Lordship.
Why you want that it should be restored?
And the
opportunity of hearing which to be
provided. Lordship, the whole family of mine, there are 4 daughters and the mother and 1 brother. We are all living in such a society that we are blamed on the daily basis that my father is accused and convicted. If your Lordship will see the order, only 2 lines of the order, and your Lordship will feel that on the merits it must be heard. I have not seen any judgment of any honorable High Court where only one person is charge framed under 120B, 120B, and in this case,
what merit of the case? You are
Lordship,
merit of the case. We are
just merit, my lord. I was raising the merit only because of the reason the judgment is so wrong that it definitely needs to be heard by this honorable. After all, the punishment is very high. And second, most of the benefits, pensionary benefit, has been curtailed.
Don't go to the merit. We are not hearing on merit.
Yes, Lordship.
Address on merit.
Say that. What you're telling about pensionary benefits, say that. That may be a ground.
Yes, Lordship. Those benefits has also been curtailed. Since he was in job, government job.
Where have you taken that ground in CRLMA?
Yes, Lordship. I am. Currently
No ground has been taken.
The ground is not there in the CRLMA. That was the only valid ground. Wonderful.
Lordship, point 9 may be seen, although that thing is missing, that pensionary benefit, that appellant is a
that's
very
not a
good
ground.
case.
It's not a ground to it. You take that, you withdraw that, you file a better one with detail. This CRLM has been filed to recall the order dated one and to restore this one. So after arguing for some time, Mr. Sam Manohar, Land Council, appearing to virtual mode, seeks permission to withdraw this CRLM to file a better application. Disclosed of this next.
Obliged, Lordship.
Number 17, the hearing is.
Idhar.
No. Interim bill, the surrender certificate, that got information, they surrender. The instruction it is in the list.
Here no instruction.
It's already surrender on 15. Certificate was
17, लिखिए जो JCRL number 5 of 2010. The Land Council for the Mr. Jafrullah Land Council submits that after availing the interim bail order as per order dated 1/10/2024 passed in IN number 1 of 2019, the appellant has already surrendered. Since the Land Council for the appellant has not produced the surrender certificate, let the register judicial obtain instruction from the Land and Trial Court as to whether the submission made by the Land Council for the appellant is correct or not. File be placed before the register judicial. Shall send email to the Land and Trial Court to obtain the report should reach on or before one matter be placed to so yes.
My lord, item 15 is ready fine.
Yes.
2011 to
Hmm.
but present whereabouts is not known. Almost in chat office and then mobile and it is not ଆମ ପାଖେ ବି କିଛି ଖବର ନାହିଁ whatever you ଅଛି କିଛି hearing time maybe around 48-50 ଦେଖୁଥିଲି ସେମିତି ବି ବସି ବୟସ ନୁହେଁ କି I don't.
Yesterday, Lordship took the views and in these old matters, the information may be.
Already the information has been sought for.
He has already been, no, this man is on bail, was on bail.
2011 to
information.
Communication has been made to ascertain whether the investigating officer is alive. Some time. अच्छा आपको रिपोर्ट मगे थिले जे तारो से कौन आसला रिपोर्ट there was an order that but to obtain specific instruction in the order dated 21/11/2023
29/9/23 रे ଗୋଟେ report ଆସିଛି
कौन आसी
since he has not returned back to the village, nobody in the locality could able to tell his present whereabouts. The fresh reports whereabouts from Rautala, IAC Brahmani.
My lord is asking that the investigating officer भी alive अच्छे में से information भी हो गई.
investigating officer कौन करियो
I also.
Let's say investigation मतलब ता जाकर out है. Investigation है ना IAC.
अपन को order दिया.
तो बोलिए
Last part.
whether the appellant
last officer probably had thought of taking additional evidence under section 391. अच्छा এটা ভাবি সেইট লাগি অর্ডারটা
whatever it may be, we just want to know that whether the appellant is there or not. So
Face instruction will be obtained.
So if you have no instruction, then
नहीं जोटा आसीची 23 मसीहारे ता सब्सिक्वेंट आउ आसीन सब पिछला चेक जाई ना 4/26 देतला तापर आसीन ना 1 week time they allow to payment.
for dying declaration, it was that 161 statement of the deceased was recorded by the IO. And
ଦିଟା
that,
ଆଇଓ ଥିଲେ ତ
ହଁ?
ଦିଟା ଆଇଓ
ହଁ।
ଆଗ 307 ରେ ହେଇଥିଲା ସେତେବେଳେ ଜଣେ ଆଇଓ ଥିଲେ
ସିଏ ରେକର୍ଡ କରିଥିବେ 161 ତାପରେ ମରି ଯାଇଥିବ
ତାପରେ ସବସିକ୍ୱେଣ୍ଟଲି ମଲା ପରେ ଆଇଆଇସି ହେଇଛନ୍ତି ଆଇଓ
ହୁଁ।
ସୋ ଯେ ଯୋଉ ସବ୍ ଇନ୍ସପେକ୍ଟର ଯିଏ ଥିଲେ ଆଇଓ ସେ ରେକର୍ଡ କରିଥିଲେ
ସେ
ଯେ
ତାଙ୍କ ଷ୍ଟେଟମେଣ୍ଟ ପ୍ରୁଭ
Perhaps,
କରିଥିଲେ ଡାଇଂ ଡିକ୍ଲାରେସନ ହେଇଥାନ୍ତା
perhaps we put a question on that day. I do not know that too. Exactly don't remember that why this exhibit 1 will not be treated as a dying declaration. Because he was when the 161 statement of the deceased was recorded, he gave the statement as to how he sustained the injury. Thereafter, the death took place.
after 8 days
So whatever it may be, so it is in connection with
Yes.
that.
ଆଜ୍ଞା
So it can be treated as dying declaration. So
ଅଛନ୍ତି ବି ଯୋଉମାନେ କହିଛନ୍ତି ଓରାଲ ଡାଇଗ୍ନୋସିସ୍ ଆମେ କହିଛୁ ବୋଲି but how far that
so no, that is why perhaps
you know
we wanted to know that since ସେ ତା ଉପରେ କିଛି question ହିଁ ପଚାରିନାହାନ୍ତି ସେ ଯୋଉ ତେଣୁ ଏ ଜିନିଷ ମୁଣ୍ଡରେ ନାହିଁ ଯେ ସେଇଟା ଗୋଟେ ୟୁଟିଲାଇଜ ହେଇପାରିବ ବୋଲି ତାଙ୍କ ଏଗେନଷ୍ଟ ବୋଲି ତେଣୁ ମେ ବି ଦ୍ୟାଟ୍ on exhibit 1 no question has been put to the IO and this is to be recorded in the at least suggestion can be given that no such statement has been given by the deceased and this exhibit 1 is a manufactured document. So otherwise that remains unchallenged. Once this 160 remains challenged and it is used as a dying declaration,
that can be that
then,
from the basis
then
of
so that is how we wanted to know whether the IO is alive or not. Also, that information was also we got on that day. So you just obtain the fresh instruction in the meantime. The Learning Council for the state seeks some further time to obtain instruction as per the order dated. Say order ta ko ame lekhi douchu au repeat kornu as per the order dated 21/11/2020. है ना? Now we clear that why we mentioned that investigation to kahinki bonchichi beli सेटा होची उद्देश्य थिला है ना? And we'll take up this matter on 17th. In the meantime, you obtain the instruction. That's all.
Thank you.
Problem.